Q. 1. Discuss the salient features of Indian Constitution. Ans. The Constitution of India is largest and most detailed constitution in world. It originally consisted of 395 articles divided into 22 parts and 8 schedules. The framers of Indian Constitution sought to incorporate the good provisions of all the existing constitutions of different countries in the world. Indian Constitution has borrowed parliamentary system of government from British Constitution. Framers of Indian Constitution incorporated provisions of fundamental rights from the Constitution of United States of America, directive principles of state policy from Ireland, power of judicial review to the Supreme Court has been taken from the Constitution of United States of America. Similarly, India's federalism has been benefited from American provisions in this area. The Constitution of Canada and Australia have also been used to some extent for laying down some provisions of Constitution of India. The Constitution of India occupies a unique place among the federal constitutions of the world. This is due to its distinctive features. The chief characteristics of Indian Constitution are as follows. 1. Longest constitution of the world. The Indian Constitution is lengthiest and most detailed of all written constitutions of the world. While the American Constitution originally consisted of 7 articles, Australian Constitution 128 and Canadian Constitution 147, and Indian Constitution originally had 395 articles. But till 78 the Amendment Act of 1995 it consists of 443 articles. The Indian Constitution lays down the structure not only of central government but also of the states. The American Constitution, on the other hand, leaves the states to draw up their own constitution. Because of peculiar problem of India like population, minorities, scheduled class, scheduled tribe community peoples, it had to incorporate many provisions. 2. Democratic form of government. The Constitution of India constitutes India into a sovereign democratic republic. It thus provides for the establishment of a democratic form of government in the country. Justice, liberty, equality and fraternity, which are essential characteristics of a democracy, are declared in the Preamble as the very objectives of the Constitution. In a democracy, the government derives all its authority from the will of the people. Our rulers are elected representatives of the people and are responsible to the people. A sovereign government is a government which is not dependent upon any outside authority. India is a free and an independent country and free to determine its external and internal policies according to its own will. 3. Sovereignty of the people. The Preamble of the Constitution declares that the people of India have adopted and given to themselves this Constitution in exercise of their sovereign rights. The words "We the people of India, in our Constituent Assembly, do hereby adopt, enact and give to ourselves this Constitution" make it clear that the real power is in the hands of the people of India, both in the Union and in the states. The vesting of sovereignty in the people of the land marks the culmination of the struggle for independence and constitutes the cornerstone of the future constitutional progress. 4. Parliamentary form of government. The Indian Constitution establishes a parliamentary form of government of India both at the centre and in the states, as distinguished from the presidential form of the government in America. The essential characteristics of parliamentary form of government are the following. A. The head of the state, i.e. the president, is the nominal and constitutional head, but the real executive power is vested in the Council of Ministers, whose head is the Prime Minister. B. The Council of Ministers is collectively responsible to the Lok Sabha. C. The members of the Council of Ministers are the elected members of the legislatures directly elected by the people. On the other hand, in a presidential form of the government, the head of the state, i.e. the president, is the real executive directly elected by the people and responsible to the people. 5. Fundamental rights. The Constitution of India contains a long list of fundamental rights of citizens. These rights are necessary for the development of individuals' personality. The legislature and the executive cannot take away these rights unless it is necessary to do so in the public interest. These rights are, however, not absolute rights. They are restricted rights and can be restricted, abridged, and taken away when it is necessary in the public interest. 6. Directive Principles of State Policy. The directive principles of state policy contained in Part 4 of the Constitution set out the aims and objectives to be followed by the state in the governance of the country. Although they are not justiciable in the courts of law, yet they are very important and fundamental in the governance of country. No government can ignore them. There is a political sanction behind them. The central and state governments are answerable to the electorate at the time of election for their implementation. The idea of the welfare state can be achieved only by implementing the various directive principles contained in the Constitution. Seven. Mixture of rigidity with flexibility. A rigid constitution is one which requires a special procedure for amendment of its provisions, while in a flexible constitution the provisions of the constitution can be amended by an ordinary legislative process. A written constitution is generally said to be rigid. The Indian constitution, though written, is sufficiently flexible. It is only a few provisions of the Constitution which can only to amended by special procedure, i.e. requiring the consent of the half of state legislature. Majority of provisions of Constitution can be amended by Parliament by ordinary legislative process. Eight. Fundamental duties. As per the recommendation of the Swarn Singh Committee, Chairman, Congress Committee on Constitutional Amendment, by the 42nd Amendment Act, 1976, 10 fundamental duties have been added in the Part 4A, Article 51-A of the Indian Constitution. It shall be the duty of every citizen of India to abide by all the fundamental duties. 9. Distribution of legislative powers. The Indian Constitution contains 3 lists under 7th Schedule. I. Union List, Article 246, 1, and SCH 7. This list contains 97 subjects. Parliament has exclusive power to make laws with respect to any of these subjects. 2. State List, Article 246, 3, and SCH 7. This list contains 66 subjects. The legislative of any state has exclusive power to make laws with respect to any of these subjects. 3. Concurrent List, Article 246, 2, and SCH 7. This list contains 47 subjects. Parliament and legislature of any state both have power to make laws with respect to any of these subjects. Residuary powers under Article 248 of the Indian Constitution. Residuary powers are vested in the centre. Exceptions. Articles 249, 250, 252 and 253 provides that Parliament can make laws on a matter specified in the state list in circumstances mentioned in these arts. 10. Administrative relations between Union and states. Articles 256 to 263 deals with Union control over states even in normal times through following ways. I. Direction by Union to the state governments. Articles 256, 257 and 356. 2. Delegation of Union's function to the states. Article 258. 3. All India Services. Article 312. 4. Grant and aid. V. Disputes relating to water. 6. Public Acts, Records and Judicial Proceedings. Article 261. 7. Coordination between states. Provision for interstate council. Article 263. 11. Unique federation. India is a unique federation. It provides several unique features such as I. No dual citizenship. There is single citizenship. I. Citizen of India. 2. At the time of emergency, it acquires a unitary character. 12. Uniformity in all basis matters. The Indian Constitution adopts 3 means to maintain administrative and legislative unity. I. A single judiciary. 2. Uniformity of fundamental laws, civil and criminal, and 3. Common all India services. 13. Independent judiciary. The following provisions are intended to secure independence and impartiality of Supreme Court and High Courts. I. Appointment of judges by President after consultation with judicial authorities. Articles 124 to 217. 2. Security of tenure is guaranteed to every judge. Articles 124, 218. 3. Salaries are fixed and cannot be varied by legislature except during the period of proclaimed emergency. Article 360. 4. Once appointed, their privileges, rights and allowances cannot be altered to their disadvantage. Article 125, 221. We, Supreme Court and High Court, recruit their own staff and frame rules regarding conditions of service. Articles 146, 229. 6. Salaries and allowances of judges is not put to the vote of legislature. Articles 146, 229. 7. Salaries, allowances and pensions of its officers are charged on the Consolidated Fund of India. Articles 146, 229. 8. The Constitution bars judges of Supreme Court from pleading or appearing before any court or judicial authority in India even after retirement. Articles 124, 7, 220. 9. No discussion can take place in the legislature of a state or in Parliament with respect to the conduct of any judge of Supreme Court or of High Courts in discharge of his duties. Articles 121, 211. 14. Rule of law. The Indian Constitution embodies the modern concept of rule of law with establishment of judicial system which should be able to work impartially and free from all influences. The rule of law means government on principles of law. The rule of law pervades over entire field of administration, and every organ of state is regulated by the rule of law. Sir Edward Coke, the Chief Justice in James I's reign was the originator of this concept. There are three meanings of the rule of law. I. Supremacy of law. 2. Equality before the law. 3. Predominance of legal spirit. 15. Doctrine of judicial review. It means that the courts have power to examine laws and executive acts and test their conformity with the Constitution and struck them down if they are found to be inconsistent with it. Article 13(2) provides that the state shall not make any law which takes away or abridge the fundamental rights, and any law made in contravention of this provision shall to that extent of inconsistency is void. 16. Adult suffrage. Under Article 326, every man and woman above 18 years of age, as it has been reduced from 21 years to 18 years, White 61st Amendment Act, 1988, has been given right to vote in elections for Parliament, State Assembly. 17. Single citizenship. According to federal principle, the Constitution of USA provides for dual citizenship, I. Citizenship of USA and citizen of the state. Though the Indian Constitution has adopted the federal principles, but Indian Constitution has provided for single citizenship, I. Citizenship of India. Q. To what is the nature of Indian Constitution? Is it correct to say that Indian Constitution is federal in character with unitary features? Or Constitution of India is neither purely federal nor purely unitary, but is combination of both. It is union of composite states of a novel type. It enshrines the principle that in spite of federation, the national interest ought to be paramount. Discuss this statement. Ans. All constitutions are generally divided into two categories, one federal and the other unitary. Under the unitary constitution, the powers of the government are centralized in one government, and that is generally the central government, and the states are subordinate to it. But in a federal constitution, there is division of powers between the center and the state, and both are independent as well as coordinate to each other. The American Constitution is universally regarded as an example of federal constitution. It established dual polity or dual form of government. A federal constitution usually has following essential characteristics. One. Distribution of powers. A federal constitution defines and demarcates the sphere of the central and state government. Each government has to act within its own sphere and cannot encroach upon the field of others. The basis of such distribution of powers between center and state is that the matters which are of national importance and in which uniform policy is desirable are given to the center, and the matters which are of local importance are given to the states for legislation and control. 2. A written constitution. A federal constitution is necessarily a written constitution. Distribution of powers can be made between the central and state governments only when there is a written constitution. All organs of the government derive their powers from the Constitution and have to function within the defined limits. The validity of all legislative enactments is tested according to the provisions of the Constitution. 3. Supremacy of the Constitution. Under a federal system, Constitution is supreme. All organs of the government have to work within the spheres assigned to them by the Constitution, and they cannot encroach upon the jurisdiction of other organs. The judiciary has to interpret the Constitution and has to see that there is no transgression of jurisdiction by different organs of the government in the spheres assigned to others. The disputes between different organs of the government are settled according to the provisions of the Constitution. 4. Effective role of the courts. The courts under a federal constitution have the final authority to interpret the constitution and maintain the supremacy of the constitution. They decide the disputes between the central and state governments. Their decisions on intergovernmental disputes are final. Besides, the courts are the savior of fundamental rights of the citizens of the country. 5. Rigidity. A natural corollary of a written constitution is its rigidity. In a rigid constitution, procedure for its amendment is very complicated. This, however, does not mean that constitution would be legally unalterable. It simply means that power to amendment constitution should not remain exclusively with either central or state government. The Constitution of India possesses all the above stated characteristics of a federal constitution. Constitution of India also provides for dual polity, system of governance at central level and state level, and there is division of power at center and state level, and each level of government is supreme in its sphere. Similarly, Indian Constitution is written and supreme, and procedure of its amendment is difficult as per federal character. Constitution established Supreme Court of India to decide dispute between center and state or states inter se, other constitutional matters. In state of WBV, Union of India, AIR 1963 SC 1241, Supreme Court has held by majority that it is not truly federal. However, Subha Rao J. in his dissenting view treated Indian Constitution basically federal. However, some scholars are of the view that Indian Constitution is not federal. In following matters they point out that the Indian Constitution contains modifications of federal principles and make it more unitary than federal. A. Appointment of governors. The governors of states are appointed by the President of India, Articles 155 and 156, and answerable to him. There are provisions in Constitution under which the governor is required to send certain state laws for the assent of President. The President has power to veto those state laws, Article 200 to 88A. However, there are not many examples where President has vetoed the state laws. The only example is Kerala Education Bill, Kerala Education Bill AIR 1958 SC 956. B. Parliament's power of legislation in the national interest. Under Article 349, Parliament is empowered to make laws with respect to every matter enumerated in state list, if the Rajya Sabha passes a resolution by 2/3 majority that it is necessary in the national interest. C. Parliament's power to form new states and other boundaries of existing states. Article 3 empowers Parliament to form new states out of the existing states, and to increase or diminish the area of any state, and to alter the boundaries or name of any state. D. Emergency provisions. The Constitution envisages three types of emergencies: emergency arising out of war or external aggression or armed rebellion, Article 352, arising out of failure of constitutional machinery in states, Article 356, and financial emergency, Article 360. When the proclamation of emergency is made under Article 350 to the normal distribution of powers between the centre and states undergoes a vital change. Parliament is empowered to make laws with respect to any matter enumerated in the state list. Under Article 356, if the President is satisfied that the government of a state cannot be carried on in accordance with the provisions of Constitution, he can dismiss the state ministry and dissolve the legislature and assume all the functionaries of the state. It is true that the above-mentioned provisions modify the federal character of the Constitution. During emergency, the Constitution is converted into a unitary Constitution. But when emergency is over, the Constitution functions as a federal Constitution. The framers incorporated these provisions on practical considerations, taking note of the peculiar problems of the country. They adopted the federal principle applicable to other federations and modified it to suit the Indian Constitution so as to serve the need of the country. The Indian Constitution, therefore, constitutes new bold experiment in the area of the federation. The Indian Constitution is neither purely federal nor unitary, but it is a combination of both. This combination of unitary and federal system is the unique feature of the Indian Constitution. The Indian Constitution is mainly federal with unique provisions for safeguarding the unity and integrity of the country. Q3. What is Preamble? Discuss the meaning and importance of the Preamble. Or examine the importance of the Preamble of the Constitution and its relevance in interpreting the provisions of Constitution. Ans. Preamble of Constitution of India. Preamble of Constitution of India is important aspect of it as it sets out the main objectives which Constitution seeks to secure for the people. The Constitution makers gave to Preamble the place of pride. It embodies all ideals and aspirations for which country had struggled during British regime. In Berubi's case AIR 1960 SC 845, Supreme Court has said that the preamble to the Constitution is a key to open the mind of the makers and shows the general purpose for which they made the several provisions in Constitution. The Preamble of Indian Constitution declares, "We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic and to secure to all its citizens justice, social, economic and political liberty of thought, expression, belief, faith and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation." In our Constituent Assembly this 26th day of November, 1949 do hereby adopt, enact and give to ourselves this Constitution. In Berubi's case AIR 1960 SC 845, 1960 SCJ 933, Supreme Court did not consider Preamble as part of Constitution. It observed the Preamble is not a part of the Constitution and it has never been regarded as source of any substantive power conferred on Government of the Indian Union or on any of its department. Such powers embrace only those expressly granted in the body of Constitution and such as may be implied from those so granted. But in Keshwananda Bharti's case AIR 1973 SC 1461, Supreme Court rejected the above view and held that Preamble is a part of Constitution. The then Hobbieli Chief Justice Sikri has observed in this case as follows: "It seems to me that the preamble of our Constitution is of extreme importance and the Constitution should be read and interpreted in the light of the grand and noble vision expressed in the preamble." In fact, the preamble was relied on in infusing implied limitations on the amending power of the Parliament under Article 368 of the Constitution. In this case, it was held that the basic elements of the preamble cannot be amended under Article 368. In S.R. Bommai v. Union of India, AIR 1994 SC 1918, Hobbieli K. Ramaswamy J. has observed the preamble of the Constitution is an integral part of the Constitution, democratic form of government, federal structure, integrity and unity of nation, secularism, socialism, social justice and judicial review are basic features of Constitution of India. The preamble of Constitution serves the following purposes as the matters of its importance. 1. It indicates the source from which the Constitution comes into existence, i.e. the people of India. 2. It contains the enacting clause which brings into force the Constitution. 3. It declares the rights and freedoms which the people of India intended to secure to all citizens and the basic structure of the government and the polity which was to be established. The objectives of the Constitution. The objectives of the Republic is to secure to its people justice, liberty and fraternity, the dignity of the individual, and the unity and integrity of the nation. Although these expressions have not been precisely defined in the Constitution, but they are not mere platitudes, for they have been given contents by Part 3 and 4 of the Constitution dealing with fundamental rights and the directive principles of the state policy. In Keswanand Bharti's case, it has been held that the preamble is a part of the Constitution and therefore it can be amended by Parliament under its amending power under Article 368. However, the only limitation on the amending power of Parliament is that it should not exercise its amending power so as to destroy the basic features in the preamble. In Research Centre v. Union of India, AIR 1995 SC 922 Supreme Court observed the preamble and Article 38 of the Constitution of India, the supreme law, envisions social justice as its arch to ensure life to be meaningful and livable with human dignity. The Constitution commands justice, liberty, equality and fraternity as supreme values to usher in egalitarian social, economic and political democracy. Social justice, equality and dignity of persons are cornerstones of social democracy. The concept social justice which the Constitution of India engrafted consists of diverse principles essential for the orderly growth and development of personality of every citizen. Social justice is thus an integral part of justice in generic sense. Justice is the genus, of which social justice is one of its species. Q. 4. Discuss how a new state can be formed. What is the procedure for changing boundaries of existing states under the Constitution? Ans. Under Article 3 of the Constitution, a new state can be formed or established in following ways. 1. By separation of territory from any state, or 2. By uniting two or more states, or 3. By uniting any part of a state, or 4. By uniting any territory to a part of any state. Under this article, Parliament can increase or decrease the area of any state, or alter the boundaries or change the name of any state. Article 3 deals with the formation of a new state out of the territories of the existing states. The power to form new states under Article 3A includes the power to form a new state of union territory by uniting a part of any state or union territory. The word state in Article 3 clauses A to C include a union territory also. The Constitution empowers the Parliament to alter the boundary or names etc. of the states without their consent. A new state may be formed an area boundary or names of the existing states may be altered by simple majority in the Parliament. The following are the conditions for passing such a law. 1. No bill for the formation of new states or the alteration of the boundaries or names of the existing state shall be introduced in either House of Parliament except upon the recommendation of the President. 2. If the bill affects the area boundaries or names of the states, President is required to refer the bill to the legislature of the state so affected for expressing its views within the period specified by the President. The President may extend the period so specified. If the state legislature to which the bill has been referred does not express its views within the period specified or extended, the bill may be introduced in the Parliament even though the views of the state have not been obtained by the President. If the state legislature expresses its views within the time so specified or extended, the Parliament is not bound to accept or act upon the views of the state legislature. Further, it is not necessary to make fresh reference to state legislature every time an amendment to the bill is proposed and accepted. Thus it is clear that the very existence of a state depends upon the sweet will of the central government. By simple majority and by ordinary legislative process, Parliament may form a new state or alter the boundaries, etc. of existing states and thereby change the political map of India. However, it is important to point out here that under Article 3 Parliament does not have power to cede any Indian territory to a foreign state. In Berubi's case AIR 1960 SC 845 Government of India entered into an agreement with Pakistan government for resolving certain boundary disputes which provided for the transfer of certain territory to Pakistan. It was held that Parliament could not do so by passing a law u Article 3 of the Constitution. The court held that this could only be done by amendment of the Constitution under Article 368. Q5. What do you understand by citizenship under the Constitution of India? Who are Indian citizens under the Constitution? Ans. What is citizenship? Citizenship connotes certain rights, duties, privileges, and obligations. A citizen of a state is a person who enjoys full civil and political rights, while those who do not have such rights are called aliens. Citizenship means that the citizen shall receive certain care, protection, facilities, be entitled to hold offices, be eligible for recruitment to public services, and be subjected to certain obligations such as taxation, etc. Under the Indian Constitution, certain fundamental rights are available only to citizens. Aliens do not enjoy these rights. The rights exclusively enjoyable by the Indian citizens are enumerated under Articles 15, 16, 19, 29, 30, 58, 1A, 67, 3A, 124, 3 to 17, 2, 157, 165 and 76, 1 of the Constitution. No person who is not a citizen of India has a right to vote for election to the Houses of the Parliament and the state legislative assemblies, nor can be he a member thereof. How citizenship is acquired under the Constitution? The Constitution does not contain extensive law on the subject. It lays down certain rules relating to citizenship. These provisions of the Constitution states the classes of persons who are, or who may be deemed to be Indian citizens at the commencement of the Constitution. As regards other things, it provides that Parliament may by law make provisions with respect to the acquisition and termination of citizenship and all other matters relating to citizenship. Pursuant to this constitutional power, Parliament has enacted a special act, the Indian Citizenship Act, 1955. Articles 5 to 8 contain the provisions determining the citizenship of India at the commencement of the Constitution, that is, 26th January 1950. The following are the persons who become citizens of India at the commencement of the Constitution. 1. Citizenship by domicile, Article 5. 2. Citizenship by migrants from Pakistan, Article 6. 3. Citizenship of migrants to Pakistan, Article 7. 4. Citizenship of Indians abroad, Article 8. 1. Citizenship by domicile. According to Article 5, a person is entitled to citizenship by domicile if he fulfills the following two conditions. Firstly, he must, at the commencement of the Constitution, have his domicile in territory of India. Secondly, such person must fulfill any of the three conditions laid down in Article 5. I. He was born in India. 2. Either of his parents was born in India. 3. He must have been ordinarily resident in the territory of India for not less than 5 years immediately before commencement of the Constitution. Domicile is an essential element for determining the citizen of the country. The term domicile has nowhere been defined in the Constitution. In Mohammad Razavi, State of Bombay, AIR 1966 SC 1436, the Supreme Court has held that the term domicile means a permanent house or place where the person concerned resides with the intention of remaining for an indefinite period. In Pradeep Jain v. Union of India, 1984, 3 SCC 654, it was held that the domicile of a person is in that country in which he either has or is deemed by law to have his permanent house. Domicile is of two kinds, i.e. domicile of origin and domicile of choice. The former is acquired by the individual by birth, and the latter is acquired by the individual by residence in a territory with the intention to reside there permanently. Article 5 recognizes only one domicile, i.e. domicile of India. In Abdus Samad v. State of WB, AIR 1973 SC 505, it was observed that to attract Article 5, C of Constitution, person applying must have Indian domicile. Domicile means to the place which a person has fixed as a habitation of himself and his family, and not for mere special and temporary purpose, but with the present intention of making it his permanent home. Domicile denotes connection with the territorial system of law. 2. Citizenship of persons who have migrated to India from Pakistan. Notwithstanding anything in Article 5, a person who has migrated to the territory of India from the territory now included in Pakistan shall be deemed to be a citizen of India at the commencement of this Constitution if a. He or either of his parents or any of his grandparents was born in India as defined in the Government of India Act, 1935, as originally enacted, and b. I. In the case where such person has so migrated before the 19th day of July, 1948, he has been ordinarily resident in the territory of India since the date of his migration, or 2. In the case where such person has so migrated on or after the 19th day of July, 1948, he has been registered as a citizen of India by an officer appointed in that behalf by the Government of the Dominion of India on an application made by him therefore to such officer before the commencement of this Constitution in the form and manner prescribed by that government. Provided that no person shall be so registered unless he has been resident in the territory of India for at least 6 months immediately preceding the date of his application. 3. Citizenship of migrants to Pakistan. Article 7 provides that notwithstanding anything in Articles 5 and 6, a person who has migrated to Pakistan after March 1947 shall not be deemed to be citizen of India. Thus, a citizen by domicile under Article 5 and a Pakistani migrant to India under Article 6 ceases to be a citizen of India if he has migrated to Pakistan after March 1947. But a person who has returned to India under a permit for resettlement or permanent return issued by or under the authority of any law is entitled to become citizen of India if he fulfills other conditions necessary for immigrants from Pakistan after July 1948 under Article 6. He can get himself registered as a citizen of India in the form and manner prescribed by the Government of India. In state of MPV, PR mode, AR 1963 SC 645, it was observed that a person shall not deem to be citizen of India is one who has after the first day of March 1947 migrated from the territory of India to territory of Pakistan. It is true that migration after 26th January 1950 would be migration after the first day of March 1947. But it is clear that a person who has migrated after 26 January 1950 cannot fall within the relevant clause because the requirement of the clause is that he must have migrated at the date when the Constitution came into force. Has migrated in the context cannot possibly include cases of persons who would migrate after the commencement of the Constitution. It is thus clear that it is only persons who had migrated prior to the commencement of the Constitution that fall within the scope of Article 7. Article 7 refers to migration which has taken place between the IST day of March 1947 and 26 January 1950. The question about the citizenship of persons migrating after 26 January 1950 will have to be determined under the provisions of Citizenship Act. 4. Citizenship of India abroad. According to Article 8, a person residing outside India shall be deemed to be a citizen of India if he fulfills the following two conditions: I, he or either of his parents or any of his grandparents must have been born in undivided India, and 2. He must have been registered as a citizen of India by the diplomatic or consular representatives of India in the country where he is for the time being residing on an application made to such representative in prescribed form and manner. According to Article 9, no person shall be citizen of India by virtue of Articles 5, 6 and 8 if he has voluntarily acquired the citizenship of a foreign state. In state of UPV, Shah mode, AR 1969 SC 1234, it was observed that Article 9 deals with cases where citizenship of foreign state has been acquired by Indian citizen prior to Constitution and means that he cannot claim citizenship of India by virtue of Article 5, 6 or 8. Q6 describe the manner in which citizenship can be acquired and terminated under the Citizenship Act 1955. Ans. Pursuant to the exercise of its power under Article 11 of the Constitution, Parliament has passed the Citizenship Act 1955. This Act provides for the acquisition of the Indian citizenship after the commencement of the Constitution in 5 ways. 1. Citizenship by birth. Every person born in India on or after 26 January 1950 shall be a citizen of India by birth. 2. Citizenship by descent. A person born outside the territory of India on or after 26 January 1950 shall be a citizen of India by descent if his father was a citizen of India at the time of his birth. 3. Citizenship by registration. Section 5 of the Citizenship Act provides that the citizenship by registration may be acquired by the following persons: A person of Indian origin ordinarily resident in India and residing there for 6 months immediately preceding the application for registration. B. Persons of India origin ordinarily resident outside undivided India. C. Women married to Indian citizens. D. Minor children of Indian citizens. E. Persons of full age and capacity who are citizens of a Commonwealth country mentioned in the first schedule. 4. Citizenship by naturalization. The central government may, on application made in the prescribed manner by any person of full age and capacity who is not a citizen of countries specified in the first schedule, if satisfied that the applicant is qualified for naturalization, grant him a certificate of naturalization. The following are the qualifications for naturalization. A. He must not be a subject or citizen of a country where Indian citizens are prevented from becoming citizens by naturalization. B. He has renounced the citizenship of the other country. C. He has resided in India and or has been in government service for 12 months immediately preceding the date of application. D. During 7 years prior to these 12 months, he has resided in India or has been in government service for not less than 4 years. E. He bears a good character. F. He takes an oath of allegiance. G. He has an adequate knowledge of a language recognized by the Constitution of India. H. After naturalization he intends to reside in India or enter into service with Government of India, international organization or a society or company in India. 5. Citizenship by incorporation of territory of India. According to Section 7 of Citizenship Act, 1955, if any new territory becomes part of India, the Government of India shall specify the persons of the territory to be citizens of India. 2. Termination of citizenship. A citizen of India by naturalization, registration, domicile and residence may be deprived of his citizenship by an order of the central government, Section 9, 10, on the ground of obtaining the citizenship by fraud or misrepresentation, disloyalty towards the Indian Constitution, communication with India's enemy during war, imprisonment for longer than 2 years within 5 years of registration or naturalization, or residing outside India for longer than 7 years at a time. This provision does not apply during a war in which India may be engaged until the government otherwise directs, under Rule 30 of the Citizenship Rules, the authority to determine whether an Indian citizen has acquired citizenship of another country or not. The authority then reports its findings to the central government, which is usually guided by the authority's recommendations. The authority is to act in a quasi-judicial capacity while discharging its function. Q. 7. What is the scope of definition of state in Article 12 of the Constitution? Does it include judicial and incorporated bodies? Ans. Part 3 of Constitution of India contains the list of fundamental rights available to citizen of India. This chapter of Constitution has been described as Magna Carta of India. The inclusion of Chapter of Fundamental Rights in the Constitution of India is in accordance with the trend of modern democratic thoughts. Fundamental rights were deemed essential to protect the rights and liberties of the people against the encroachment of the power delegated by them to their government. In Maneka Gandhi v. Union of India, AIR 1978 SC 597, it was observed, their fundamental rights represent the basic values cherished by people of India since Vedic times, they are calculated to protect the dignity of individual and create conditions in which every human being can develop his personality to the fullest extent. They weave a pattern of guarantee on the basic structure of human rights and impose negative obligations on the state not to encroach on individual liberty in its various dimensions. The fundamental rights as incorporated in Indian Constitution can be classified in following groups. I. Right to equality. Article 14 to 18. 2. Right to freedom. Article 19 to 22. 3. Right against exploitation. Article 23 to 24. 4. Right to freedom of religion. Article 25 to 28. We. Cultural and educational rights. Article 29 to 30. 6. Right to constitution remedies. Article 30 to 235. Fundamental rights given to citizens of India are a guarantee against state action as distinguished from violation of such rights from private parties. Definition of state. Article 12 defines the term state as used in Articles of Part 3 of the Constitution. It says unless the context otherwise requires, the term state includes the following. 1. The Government and Parliament of India, i.e. executives and legislature of the Union. 2. The Government and the legislature of each state, i.e. executives and legislature of states. 3. All local and other authorities within the territory of India. 4. All local and other authorities under the control of Government of India. So the term state includes executive and legislative organs of the Union and state. Article 12 does not make any reference to judiciary, and therefore the decision of a regularly constituted court cannot be challenged as interfering the fundamental rights. In Central Inland Water Transport Corp Limited v. Brojo Nath Ganguly, AIR 1986 SC 1571, it was observed that the definition of expression, the state in Article 12 is for the purpose of Part 3 and 4 of the Constitution. The contents of these two parts clearly show that the expression, the state in Arti 12 as also used in Article 36 is not confined to its ordinary and constitutional sense as extended by the inclusive portion of Article 12, but is used in the concept of the state in relation to fundamental rights guaranteed by Part 3 of the Constitution and directive principles of state policy contained in Part 4 of Constitution, which principles are declared by Article 37 to be fundamental to governance of the country and enjoins upon the state to apply in making laws. The expression local authority has reference to a unit of local self-government like a municipal committee, a district board, village panchayat, improvement trust and mining settlement board. In Mohammad Yasin v. Town Area Committee, AIR 1952 SC 115, the Supreme Court held that the bylaws of a municipal committee charging a prescribed fee on the wholesale dealer was an order by a state authority which contravened the provisions of Article 19, 1g of the Constitution. These bylaws in effect and in substance have brought about a total stoppage of the wholesale dealer's business in the commercial sense. The expression, other authorities, is of vague and broad import. It means a public rather than a private authority. In Ujjain by v. State of UP, AIR 1962 SC 1621, the Supreme Court has held the view that a university maintained by a state would fall within the meaning of a state. A university is a statutory body having legislative and administrative powers. Hence, a university is held to be within the purview of the authority in Article 12. Supreme Court has held in Electricity Board, Rajasthan v. Mohanlal, AIR 1967 SC 1857 that to be within the expression, other authority, all authorities created by the Constitution or statute must get power under the law. So this interpretation, state electricity boards are the state within the meaning of Article 12. The above decision of the Supreme Court has overruled the decision of Madras High Court in University of Madras v. Shantabai, AIR 1954 Madras 67, holding that a university is not a state within the meaning of expression other authorities, as used in Article 12. In Sukhdev Singh v. Bhagat Ram, AIR 1975 SC 1331 the Supreme Court following the test laid down in Electricity Board Rajasthan's case has held that Oil and Natural Gas Commission, Life Insurance Corporation and Industrial Finance Corporation are authorities within the meaning of Article 12 of Constitution and therefore they are state. All three statutory corporations have power to make regulations under the statute for regulating conditions of service of their employees. Subsequently, Supreme Court made even more liberal and broad interpretation of expression, other authorities in Article 12. In Ramana Dayaram Shetty v. The International Airport Authority of India, AR 1979 SC 1628 Supreme Court has held that if a body is an agency or instrumentality of government it may be an authority within the meaning of Article 12 whether it is a statutory corporation, a government company or even a registered society. Accordingly, International Airport Authority, which was created by an Act of Parliament, was held to be state. In Ajay Hasia v. Khalid Majid, AIR 1981 SC 487 Supreme Court held that society registered under the Societies Registration Act 1898 is an agency or instrumentality of the state and hence is state within the meaning of Article 12. Is judiciary included in the word state? Question whether judiciary is included within expression state or not has arisen in Naresh v. State of Maharashtra, AIR 1967 SC1 where Supreme Court held that judiciary is not included in the expression of state as provided in Article 12. But in AR Antile v. R.S. Nayak, AIR 1988 SC 1531 Supreme Court held that court cannot pass an order or issue a direction which would be violative of fundamental rights of citizens, so it can be said that the expression state as defined in Article 12 includes judiciary also. Q8 describe briefly the general characteristic features of the fundamental rights. Ans. The most important characteristic feature of the fundamental rights is that they are justiciable, that is to say that they are enforceable by the courts. If by the action of the state a citizen's fundamental right is violated, he is entitled to go to the court for appropriate remedy against such action. A right without remedy is a meaningless concept. Articles 32 and 226 read with Article 13 make these rights enforceable. Under these articles the Supreme Court and High Court are empowered to issue appropriate order, direction and writs including writs in the nature of habeas corpus, mandamus, prohibition, covenanto and certiorari for the enforcement of the fundamental rights guaranteed by Part 3 of the Constitution. There are some rights which are available to the citizens of India only while some are available to all persons, citizens and non-citizens. Fundamental rights guaranteed by Articles 15, 16, 19, 29 and 30 are available to the citizens only. The rights enumerated in Part 3 of the Constitution are guaranteed against state action and not against private individual. Barring a few exceptions, the fundamental rights guarantees to the individuals are limitations on the state action. Articles 15, 2a, b, and Article 17. They are not meant to protect persons against the conduct of private persons. Against the actions of the private individuals a person can seek remedy under the ordinary law of the land. It is against the might of the state that individual needs constitutional protection. P.D. Samdasani v. Central Bank of India, AIR 1952 SC 59. Patanjali Shastri, CJ, of the Supreme Court in State of West Bengal v. Subodh Gopal, AIR 1954 SC 92 at page 97, observed, the whole object of Part 3 of the Constitution is to provide protection for the freedoms and rights mentioned therein against arbitrary invasion by the state. There are some fundamental rights which are available against specific class of persons. For example, Article 15, 2, directs the state not to discriminate against a citizen on grounds only of religion, race, caste, sex and place of birth or any of them. It also prohibits state and private persons from making discrimination with regard to access to shops, hotels, etc., and all places of public entertainment, of public resort, wells, tanks, roads, etc. Q9 read short notes on the following doctrines. A. The doctrine of severability. B. The doctrine of Eclipse. C. The doctrine of Waiver. Ans. Article 13 of the Constitution lays down as follows. 1. All laws in force in the territory of India immediately before the commencement of this Constitution, insofar as they are inconsistent with the provisions of Part 3 of the Constitution, shall be void to the extent of inconsistency with Part 3 of the Constitution. 2. The state shall not make any law which takes away or abridges the rights conferred by Part 3, and any law made in contravention of this clause to the extent of the contravention shall be void. 3. In this article, unless the context otherwise requires. A. Law includes any ordinance, order, bylaw, rule, regulation, notification, custom or usage having the force of law. B. Law in force includes laws passed or made by a legislature or other competent authority in the territory of India before the commencement of this Constitution and not previously repealed, notwithstanding that any such law or any part thereof may not be then in operation either at all or in particular areas. 4. Nothing in this article shall apply to any amendment of this Constitution made under Article 368. Effect on existing laws. Article 13, 1, is prospective in nature, that is, they operate from the date of the commencement of the Constitution and not retrospectively. All pre-Constitution or existing laws shall be void only if they are inconsistent with the fundamental rights enshrined in Part 3 of the Constitution. In Keshwa Madhva Menon v. State of Bombay, AIR 1951 SC 128 proceedings had been started against the appellant for an offence punishable US 18 of the Indian Press Emergency Powers Act 1934 in respect of pamphlet published in 1949. The appellant's contention was that the Act was inconsistent with fundamental rights conferred by the Constitution and therefore it had become void u Article 19, 1, after 26 January 1950 and the proceedings against him could not be continued. Supreme Court has held that all laws in force at the commencement of the Constitution, which are inconsistent with Part 3 of the Constitution, shall be void to the extent of inconsistency. Article 13, 1, had no retrospective effect but only prospective in its operation. A. Doctrine of severability. It is not the whole Act which would be held invalid by being inconsistent with Part 3 of the Constitution, but only such provisions of it which are violative of the fundamental rights, provided that the part which violates the fundamental rights is separable from that which does not isolate them. But if the valid portion is so closely mixed up with invalid portion that it cannot be separated without leaving an incomplete or more or less mingled remainder, the court will declare the entire act void. This process is known as doctrine of severability or separability. The Supreme Court considered this doctrine in A.K. Gopalan v. State of Madras, AIR 1950 SC 27, and held that the preventive detention minus Section 14 was valid, as the omission of the Section 14 from the Act will not change the nature and object of the Act, and therefore the rest of the Act will remain valid and effective. The doctrine was applied in D.S. Nakara v. Union of India, AIR 1983 SC 130, where the Act remained valid while the invalid portion of it was declared invalid because it was severable from the rest of the Act. In State of Bombay v. F.N. Balsara, AIR 1951 SC 318, it was held that the provisions of the Bombay Prohibition Act, 1949, which were declared as void, did not affect the validity of the entire Act, and therefore there was no necessity for declaring the entire statute as invalid. The doctrine of severability has been elaborately considered by the Supreme Court in RMDC v. Union of India, AIR 1957 SC 628, and the following rules regarding the question of severability has been laid down. 1. The intention of the legislature is the determining factor in determining whether the valid part of a statute are severable from the invalid parts. 2. If the valid and invalid provisions are so inextricably mixed up that they cannot be separated from the another, then the invalidity of a portion must result in the invalidity of the Act in its entirety. On the other hand, if they are so distinct and separate that after striking out what is invalid, what remains is itself a complete code independent of the rest, then it will be upheld notwithstanding that the rest had become unenforceable. 3. Even when the provisions which are valid are distinct and separate from those which are invalid, if they form part of a single scheme which is intended to be operative as a whole, then also the invalidity of a part will result in the failure of the whole. 4. Likewise, when the valid and invalid parts of a statute are independent and do not form part of a scheme, but what is left after omitting the invalid portion is so thin and truncated as to be in substance different from what it was when it emerged out of legislature, then also it will be rejected in its entirety. 5. The severability of the valid and invalid provisions of a statute does not depend on whether provisions are enacted in same section or different section. It is not the form but the substance of the matter that is material, and that has to be ascertained on an examination of the Act as a whole and of the setting of the relevant provisions therein. 6. If after the invalid portion is expunged from the statute, what remains cannot be enforced without making alterations and modifications therein, then the whole of it must be struck down as void, as otherwise it will amount to judicial legislation. 7. In determining the legislative intent on the question of severability, it will be legitimate to take into account the history of legislation, its object, the title and preamble of it. B. Doctrine of Eclipse. The doctrine of Eclipse is based on the principle that a law which violates fundamental rights is not nullity or void ab initio but becomes only unenforceable, i.e. remains in a moribund condition. It is overshadowed by the fundamental rights and remains dormant, but it is not dead. Such laws are not wiped out entirely from the statute book. They exist for all post-transactions and for the enforcement of the rights acquired and liabilities incurred before the commencement of the Constitution. It is only against the citizens that they remain in a dormant or moribund condition, but they remain in operation as against non-citizens who are not entitled to fundamental rights. For solving such a problem, Supreme Court formulated the doctrine of Eclipse in Bhikhaji v. State of MP, AIR 1955 SC 781. In this case, the provisions of CP and Barar Motor Vehicles Amendment Act 1948 authorized the state government to take up the entire motor transport business in the province to the exclusion of motor transport operators. This provision, though valid when enacted, but became void on the commencement of the Constitution in 1950 as they violated Article 19, 1g of the Constitution. However, in 1951 Clause 6 of Article 19 was amended by the Constitution, First Amendment Act, so as to authorize the government to monopolize any business. The Supreme Court held that the effect of the amendment was to remove the shadow and to make the impugned act free from blemish or infirmity. It became enforceable against citizens as well as non-citizens after the constitutional impediment was removed. This law was eclipsed for the time being by the fundamental rights. As soon as the eclipse is removed, the law begins to operate from the date of such removal. C. Doctrine of Waiver. Can a person waive his fundamental right? A reference to the doctrine of waiver was first made in Behram v. State of Bombay, AIR 1955 SC 123. While discussing the question of legal effect of a statute being declared unconstitutional, Justice Venkatrama Iyer gave the opinion that a law, unconstitutional by reason of its repugnancy to a fundamental right which is enacted for the benefit of individuals and not for the benefit of the general public, is not a nullity but merely enforceable, and such an unconstitutionality could be waived, in which case the law becomes unenforceable for that individual, e.g. the right guaranteed under Article 19, 1, f, is for the benefit of the owners of property, and when a law is found to infringe that provisions, it is open to any person whose right has been infringed to waive it. And when there is a waiver, there is no legal impediment to the enforcement of the law. The question of waiver directly arose in Basheshwar Nath v. Income Tax Commissioner, AIR 1959 SC 149. The petitioner, whose case was referred to the Income Tax Investigation Commissioner under Section 5(1) of the Act, was found to have concealed large amount of income. He thereupon agreed at a settlement in 1954 to pay 3 lakhs in monthly installments by way of arrears of tax and penalty. In 1955, the Supreme Court in other cases declared Section 5(1) ultra vires Article 14. The petitioner thereupon challenged the settlement between him and the commissioner. The main question that arose for consideration was whether or not the assessee had waived his fundamental right under Article 14 by entering into the settlement. In this case, the Supreme Court held a large majority of our people are economically poor, educationally backward, and politically not conscious of their rights. Individually or even collectively, they cannot be pitted against the state organizations and institutions, nor can they meet them on equal terms. In such circumstances, it is the duty of the court to protect their rights against themselves. In the end, the court upheld unanimously that the petitioner could not waive his rights under Article 14 of the Constitution. Circumstances under which fundamental rights can be curtailed or suspended. The fundamental rights can be suspended or curtailed in the following circumstances. 1. The Parliament can restrict or abrogate by law the fundamental rights in their application to the members of the armed forces or forces charged with the maintenance of public order with a view to ensure proper discharge of their duties and maintenance of discipline among them. Article 33. 2. Fundamental rights can be curtailed or restricted when martial law is in force in any area. Article 34. 3. During the period in which the proclamation of emergency is in operation, the rights conferred by Article 19 are suspended. Article 358. Also, where a proclamation of emergency is in operation, the President may, by order, declare that the right to move any court for the enforcement of such rights conferred by Part 3, except Articles 20 and 21, as may be mentioned in the order, and all proceedings pending in any court for the enforcement of rights so mentioned shall remain suspended for a period during which the proclamation of emergency is in force or for such shorter period as may be specified in the order. An order made as aforesaid may extend to the whole or any part of the territory of India. Every such order shall, as soon as may be after it is made, be laid before each House of Parliament. Article 359. 4. All or any of the fundamental rights can be curtailed, suspended, or modified by an amendment of the Constitution itself under Article 368. Q. 10. What is meant by the rule of law? Discuss the principle of equality before the law in the Indian Constitution and distinguish it from the equal protection of the law. Or Q. Is making of classification contrary to the guarantee of right of equality under Article 14 of the Constitution valid? Ans. Rule of law. Article 14 of the Constitution of India declares that the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of law. Expression equality before law is what A.V. Dicey has called rule of law. The principle enunciated in this concern by Dicey can be summed up as follows. 1. No man is punishable or can be lawfully made to suffer in body or goods except for a distinct breach of the law established in the ordinary legal manner before the ordinary way by person in authority. 2. No man is above the law. Every man, irrespective of his rank and condition, is subject to the jurisdiction of ordinary courts. So the rule of law may be defined as a recognition of the supremacy of law, the equal subjection of all persons to it. The government as well as governed are subject to the law. In Bachan Singh v. State of Punjab, AIR 1982 SC 1325 it was observed the rule of law permeates the entire fabric of the Constitution and indeed forms one of its basic features. The rule of law excludes arbitrariness, its postulate is intelligence without passion and reason free from desire. What is necessary element of the rule of law is that the law must not be arbitrary or irrational and it must satisfy the test of reason, and the democratic form of polity seeks to ensure this element by making the framers of law accountable to the people. So the rule of law is used in contradiction of the rule of man. The guarantee of equality before law is an aspect of what Dicey calls the rule of law. It means that no man is above the law of the land and that every person, whatever be his rank or condition, is subject to the jurisdiction of ordinary courts. The Preamble declares the object of the Constitution to secure to all its citizens equality of status and opportunity. Article 14 embodies general principles of equality and the succeeding Articles 15, 16, 17 and 18 lay down the specific application of the general rule laid down in Article 14. Article 14 of the Constitution says that the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. Equality before the law connotes equal subjection of all classes to the ordinary law of the land. It implies that every official from higher rank to the lower rank is under the same responsibility for every act done without lawful justification as any other ordinary citizen. Equality before the law is a negative concept. It declares that everyone is equal before law, that no one can claim special treatment, and that all classes are equally subjected to the ordinary law of the land. But it should be noted here that there is no such things as absolute equality. Law should be equal among equals. In other words, like should be treated alike. In Secretary, Haryana State Electricity Board B. Suresh, AIR 1999 SC 1160, it was observed that equality clause in Constitution does not speak of mere formal equality before law but embodies the concept of real and substantive equality, which strikes off the inequalities arising on account of vast social, economic differentiation and is thus consequently an essential ingredient of social and economic justice. In Srinivasa Theatre v. Government, TN. AIR 1992 SC 999, it was observed. Equality before law is a dynamic concept having many facets. One facet, the most commonly acknowledged, is that there shall be no privileged person or class and that none shall be above law. A facet which is of immediate relevance herein is the obligation upon the state to bring about, through the machinery of law, a more equal society envisaged by the Preamble and Part 4 of our Constitution. Equality before law can be predicated meaningfully only in an equal society, i.e. in society contemplated by Article 38 of the Constitution. Equal protection of laws. The second concept, equal protection of laws, is more positive in content. This concept is borrowed from the 14th Amendment of the American Constitution. It means subjection to equal law applying to all persons in the same circumstances. All persons similarly circumstanced shall be treated similarly both in privileges conferred and liabilities imposed. Equal law should be applied to all in the same condition. In Prabhudas Morarji v. Union of India, AIR 1966 SC 1044, it was observed that to make out the case of denial of equal protection of law under Article 14 of the Constitution, a plea of differential treatment is by itself not sufficient. An applicant pleading that Article 14 has been violated must make out that not only he had been treated differently from others, but he has been so treated from persons similarly circumstanced without any reasonable basis, and such differential treatment is unjustifiably made. In Jyoti Pershad v. Administrator for Union Territory of Delhi, AIR 1961 SC 16-0 to Supreme Court, while interpreting the expression equal protection of law as embodied in Article 14, has laid down following rules of guidance to check whether any enactment passed by state is violative of Article 14 or not. 1. If the statute itself or the rule made under it applies unequally to persons or things similarly situated, it would be an instance of direct violation of constitutional guarantee. 2. The enactment or the rule might not in terms enact a discriminatory rule of law but might enable an unequal or discriminatory treatment to be accorded to persons or things similarly situated. The very provision of the law which enables or permits the authority to discriminate in certain circumstances offends the guarantee of equal protection afforded by Article 14. 3. The above rule would not apply to cases where the legislature lays down the policy and indicates the rule or line of action which should serve as guidance to the authority. Where such guidance is expressed in the statutory provision conferring the power, no question of violation of Article 14 could arise. 4. For the legislation to comply with the rule as to equal protection, it is not essential that the rules for the guidance of the designated authority should be laid down in express terms. Q. 11. What Article 14 prohibits is class legislation and not reasonable classification for the purpose of legislation. Discuss. Or is making of classification contrary to the guarantee of right of equality under Article 14? Discuss fully, suitably illustrating your answer. Ans. Equal protection of laws guaranteed by Article 14 does not mean that all laws should be general in character and universal in application. It does not mean that same law should apply to all persons. Varying needs of different classes of persons often require separate treatment. In fact, equal treatment in unequal circumstances would amount to inequality. Therefore, a reasonable classification is not only permitted but it is necessary if the society is to progress. Equality is for equals, that is to say, those who are similarly circumstanced are entitled to an equal treatment. The guarantee of equality does not imply that the same rules should be made applicable to all persons in spite of differences in their circumstance and conditions. Ramesh Prasad Singh v. State of Bihar, AIR 1978 SC 327. So the guarantee of equal protection of law and equity before law does not prohibit reasonable classification. In Budhan Chaudhary v. State of Bihar, AIR 1955 SC 191 it was observed. While Article 14 forbids class legislation, it does not forbid reasonable classification for the purposes of legislation. In order, however, to pass the test of permissible classification, two conditions must be fulfilled, namely, I. That the classification must be founded on an intelligible differentia which distinguishes persons or things that are grouped together from others left out of the group, and 2. That the differentia must have a rational relation to the object sought to be achieved by the statute in question. The classification may be founded on different bases, namely, geographical, or according to objects or occupations or the like. What is necessary is that there must be a nexus between the basis of classification and the objects of the act under consideration. Article 14 condemns discrimination not only by a substantive law but also by a law of procedure. Similarly, in Vazirvelu Mudaliar v. Special Deputy Collector for Land Acquisition, AIR 1965 SC 1017 Supreme Court observed. Under Article 14 of the Constitution of India, the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. But this does not preclude the legislature from making a reasonable classification for the purpose of legislation. The said classification has to pass two tests, namely, I. The classification must be founded on an intelligible differentia which distinguishes persons and things left out of the group, and 2. The differentia must have a rational relation to the object sought to be achieved by the statute in question. In State of WBV Rash Bihari Sarkar, 1993, 1 SCC 479 equality means equality in similar circumstances between same class of persons for same purpose and objective. It cannot operate amongst unequals. But even amongst equals, the legislature or executive may classify on distinction which is real. A classification amongst groups performing shows for monetary gains and cultural activities cannot be said to be arbitrary. may be that both groups carry out legislative objective of promoting social and educational activities, and, therefore, they are alike, but distinction between the two on monetary gains and otherwise is real and intelligible. So long the classification is reasonable, it cannot be struck down as arbitrary. Likes can be treated differently for good and valid reasons. The state, in treating the group performing theatrical shows for advancement of social and educational purpose differently, on basis of profit-making, cannot be said to have acted in violation of Article 14 of Constitution. The true meaning and scope of Article 14 have been explained by Supreme Court in numerous cases. Principles as laid down in R.K. Dalmia v. Justice Tendulkar, AIR 1958 SC 538 still hold valid ground, which are follows. 1. A law may be constitutional even though it relates to a single individual if on account of some special circumstances or reasons applicable to him but not applicable to others, that single individual may be treated as a class by himself. 2. There is always a presumption in favor of the constitutionality of a statute, and the burden is upon him who attacks it to show that there has been a clear transgression of constitutional principles. 3. It must be presumed that legislature understands and correctly appreciates the needs of its own people, that laws are directed to problem, made manifest by experience, and that its discriminations are based on adequate ground. 4. The legislature is free to recognize degrees of harm and may confine its restriction to those cases where the need is deemed clearest. 5. In order to sustain the presumption of constitutionality, the court may take into consideration matters of common knowledge, matters of common report, the history of times, and may assume every state of facts which can be conceived existing at the time of legislation. 6. While good faith and knowledge of the existing conditions on the part of the legislature are to be presumed, if there is nothing on the face of law or the surrounding circumstances brought to the notice of the court on which the classification may be reasonably regarded as based, the presumption of constitutionality cannot be carried to the extent of always holding that there must be some undisclosed and unknown reasons for subjecting certain individuals or corporations hostile or discriminating legislation. 7. The classification may be made on different bases, example, geographical or according to objects or occupations or the like. 8. The classification made by a legislature need not be scientifically perfect or logically complete. Mathematical nicety and perfect equality are not required. 9. Article 14 applies to both the discrimination of the substantive law as well as procedure law. If the classification satisfies the above propositions, the law will be declared constitutional. Q. 12. Can the state discriminate between citizens on the grounds of religion, caste, sex or place of birth? Ans. Article 15 of the Constitution provides that no citizen shall be subjected to discrimination in matters of rights, privileges, and immunities pertaining to him. This article lays down 1. The state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them. 2. No citizen shall on grounds only of religion, race, caste, sex, place of birth or any of them be subjected to any disability, liability, restriction or condition with regard to a. Access to shops, public restaurants, hotels and places of public entertainment, or b. The use of wells, tanks, bathing ghats, roads and places of public resort maintained wholly or partly out of state funds or dedicated to the use of the general public. 3. Nothing in this article shall prevent the state from making any special provision for women and children. 4. Nothing in this article or in clause 2 of Article 29 shall prevent the state from making any special provision for the advancement of any socially and educationally backward classes of citizens or for the scheduled castes and scheduled tribes. Article 15 directs that the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them. Any law discriminating on one or more on these grounds would be void. The word only has been purposely used in the article. A discrimination based on one or more of these grounds and also on other grounds or grounds will not be affected by Article 15(1). It means that if one or more of the specified grounds is combined with a ground not mentioned in Article 15(1), the laws will be outside the prohibition contained in Article 15(1). Article 15(1) prohibits discrimination on the ground of birth and not that of residence. A state can, therefore, grant concessions to its residents in matters of fees in an educational institution. In Mainsavdas v. State of UP, AR 1953 SC 384, a law which provided for election on the basis of separate electorate for members of different religious communities was held to be unconstitutional. In DP Joshi v. State of MB, AIR 1955 SC 334, it was held that a law which discriminates on the ground of residence does violate Article 15(1). In that case, a rule of the state medical college requiring a capitation fee from non-Madhya Bharat students for the admission in the college was held valid as ground of exemption was residence and not place of birth. Place of birth is different from residence. In Balaji v. State of Mysore, AIR 1965 SC 649, the Mysore government issued an order under Article 15(4), reserving seats in the medical and engineering colleges in the state as follows: backward classes 28%, more backward classes 20%, scheduled castes and tribes 18%. Thus 68% of the seats available in the colleges were reserved and only 32% was made available to the merit pool. The validity of the order was challenged by candidates who had secured more marks than those admitted under the order. Though qualified on merit, they had failed to get admission only by reason of the government order. The court held that the subclassification made by the order between backward classes and more backward classes was not justified under Article 15(4). Backwardness as envisaged by Article 15(4) must be both social and educational and not either social or educational. Though caste may be a relevant factor, but it cannot be the sole test for ascertaining whether a particular class is a backward class or not. Poverty, occupation, place of habitation may all be relevant factors to be taken into consideration. Article 15(4) does not speak of castes, but only speaks classes, and caste and class are not synonymous. The impugned order, however, proceeds only on the basis of caste without regard to other relevant factors, and that is sufficient to render the order invalid. The court said that the state was not justified in including in the list of backward classes all those castes or communities whose average of student population per thousand was slightly above or very near or just below the state average. Only those which were well below the average can be regarded as backward. Thus the main defect of the system adopted by the state was that under it 90% of the population of the state was backward. It was held that this was inconsistent with Article 15(4). Reservation of 86% of seats in technical institutions, such as engineering and medical colleges, to the exclusion of all other candidates, if a single candidate from the scheduled tribes was available, would amount to fraud upon the Constitution. Clause 4 of Article 15 only enables the state to make special and not exclusive provision for the backward classes. The state would not be justified ignoring altogether advancement of the rest of the society in its zeal to promote the welfare of backward classes. In Guntur Medical College v. Mohan Rao, AIR 1976, SC 1904, an important question arose before the court as to whether a person belonging to Christian converts, who originally belonged to scheduled caste, on reconversion to Hinduism can claim the benefit of reservation of seats in a medical college under Article 15, 4. The court held that a person whose parents belonged to a scheduled caste before their conversion to Christianity can, on reconversion to Hinduism, be regarded as a member of the scheduled caste only if he is accepted as a member of that caste by the other members of the caste. On such acceptance, he would be eligible for the benefit of the reservation of the seats for scheduled caste in the matter of admission to the medical college. In State of MP Nivedita Jain, AIR 1981 SC 2045, the Supreme Court upheld the validity of an executive order of the Government of MP completely relaxing the condition of qualifying marks in the pre-medical tests. The court observed that in the absence of any law to the contrary, it is open to the government to impose such conditions as would make the reservation effective. Q. 13. How the equality guaranteed by the Constitution in the matters of public employment? Ans. Article 16, which provides for equality of opportunity in matters of appointment and employment, is only an incident to application of the equality concept envisaged in Article 14. This article gives effect to the doctrine of equality and to the prohibition of discrimination guaranteed by Article 16, 1 in the matters of public employment. Article 16 lays down: 1. There shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. 2. No citizen shall, on ground only of religion, race, caste, sex, descent, place of birth, residence, or any of them, be ineligible for, or discriminated against in respect of any employment or office under the state. 3. Nothing in this article shall prevent Parliament from making any law prescribing in regard to a class or classes of employment or appointment to an office under the government of or any local or other authority within a state or union territory, any requirement as to residence within that state or union territory prior to such employment or appointment. 4. Nothing in this article shall prevent the state from making any provision for the reservation of appointments of posts in favor of any backward class of citizens, which in the opinion of the state, is not adequately represented in the services under the state. 5. Nothing in this article shall affect the operation of any law which provides that the incumbent of an office in connection with the affairs of any religious or denominational institution or any member of the governing body thereof shall be a person professing a particular religion or belonging to a particular denomination. Article 16 guarantees equality of opportunity in matters of appointment in state services. It is to be noted that under Article 16 the guarantee against discrimination is limited to employment and appointment under the state. Article 15, however, is more general and deals with all cases of discrimination, which do not follow Article 16. What Article 16 guarantees is equality of opportunity in matters of appointment in state services. Equality of opportunity connotes that every citizen shall be eligible for the employment or appointment to any office under the state according to his qualifications and capability. It does not prevent the state from prescribing the necessary qualifications and selective tests for recruitment for government services. The selective test must not be arbitrary. In Pandaramrao v. Andhra Pradesh Service Commission, AIR 1963 SC-68, at validity of a rule prescribing that an applicant for the selection of district munsif must at that time be practicing as an advocate in the Andhra Pradesh court, was challenged under Article 16. The court held that the rule is unconstitutional as there was no reasonable nexus between the qualification and the alleged object of an applicant possessing a knowledge of the local laws which could be acquired by any lawyer practicing in any court. In C.B. Muthamma v. Union of India, AIR 1979 SC 1868, a provision in service rules requiring a female employee to obtain the permission of the government in writing before her marriage is solemnized and denying her the right to be promoted on the ground that the candidate was married woman was held to be discriminatory against women and hence unconstitutional. The petitioner was denied promotion to grade I of the Indian Foreign Service only on this ground. However, the court made it clear that it does not mean that the men and women are equal in all occupations and in all situations, and do not exclude the need to pragmatize where the requirements of particular employment, the sensitivities of sex, or the peculiarities of social sectors of the handicaps of either sex may compel selectivity. But save where the differentiation is demonstrable, the rule of equality must govern. Equal pay for equal work. In Randir Singh v. Union of India, AIR 1982 SC 879, it has been held that equal pay for equal work, although not expressly declared to be a fundamental right, is clearly a constitutional goal under Articles 14, 16 and 39 C of the Constitution, and can be enforced by the courts in cases of unequal scales of pay based on irrational classification. This principle has been followed in a number of cases. D.S. Nakara's case AIR 1983 SC 130 and P.K. Ramchandra Iyer's case AIR 1984 SC 541. In P.R. Naidu v. Government of Andhra Pradesh, AIR 1977 SC 854, the petitioners were retired compulsorily in public interest. It was held that the provision for compulsory retirement in public interest applies to all government servants. As such, Article 16 does not prohibit the prescription of reasonable rules for compulsory retirement. Article 16(4) is the second exception to the general rule embodied in Article 16(1) and 2. According to this provision, nothing in Article 16 shall prevent the state from making any provision for the reservation of appointments or posts in favor of any backward class of citizens which in opinion of the state is not adequately represented in the services under the state. The scope of Article 16(4) was considered by the Supreme Court in Devdasan v. Union of India, AIR 1964 SC 179. In this case, carry-forward rule framed by the government to regulate appointment of persons of backward class in government service was involved. The court struck down the carry-forward rules as unconstitutional on the ground that the power vested in the government cannot be so exercised as to deny reasonable equality of opportunity in matters of appointment for members of classes other than backward. Undoubtedly, Article 16(4) is an enabling provision and confers a discretionary power on the state to make reservation of appointment in favor of backward class of citizens, which in its opinion is not adequately represented, but it is not itself a fundamental right. The Supreme Court in C.A. Rajendran v. Union of India, AIR 1978 SC 507, held that it is open to state to withdraw the benefits conferred on the scheduled castes and scheduled tribes, and they have no remedy in the courts. In Air India v. Nargesh Mirza, AIR 1981 SC 1829, the air hostesses challenged the provisions which required them to retire at the age of 35 years or if they get married within 4 years of confirmation or on first pregnancy. It was held that these provisions were discriminatory and violative of Articles 14, 15 and 16 of the Constitution. In K.C. Vasant Kumar v. State of Karnataka, AIR 1985 SC 1495, the Supreme Court has suggested that the reservations in favor of backward classes must be based on mean test. It has been further suggested that the policy of reservations should be reviewed every 5 years or so, and if a class has reached up to that level where it does not need reservation, its name should be deleted from the list of backward classes. Constitution, 81st Amendment, Act, 2000. Insertion of new clause, 4-B, in Article 16. This amendment has added a new clause, 4-B, after clause, 4-A, in Article 16 which seeks to end a 50% ceiling on reservation for SCs, CENs, and BCs in backlog vacancies which could not be filled up in the previous years due to the non-availability of eligible candidates. Constitution, 85th Amendment, Act, 2001. This amendment has substituted, in clause 4-A for the words "in matters of promotion" to any class the words "in matters of promotion, with consequential seniority," to any class. This amendment aims at extending the benefit of reservation in favor of the S.C.S.T in matters of promotion with consequential seniority. That is, from April 1995 when the Constitution's 77th Amendment was enacted. In Praveen Singh v. State of Punjab, AIR 2001 SC 158, the Supreme Court has held that the recruitment to the post of Block Development Officer cannot be made on basis of viva voce test only having regard to the nature and requirement of the concerned job. Even the Service Commission has recognized a written test as also viva voce test. In this case, the facts were that the Punjab Public Service Commission issued an advertisement for 28 to 44 vacancies of block development and panchayat officers. About 4,500 people appeared in the test, and subsequently roll members of 130 candidates only were published being eligible to appear in viva voce test. After the viva voce, the final result was announced and name of candidates found suitable for appointment were published. The petitioner's name did not figure in the merit list. The petitioner thereafter challenged the selection process in the writ petition before the High Court, which was rejected. He then filed the present appeal in the Supreme Court. The court held that the appointment could not be made solely on the basis of viva voce test. The scheme of examination as given in information sheet showed that there were 4 papers for written test followed by viva voce test. It also provided that no candidate would be eligible to appear in the viva voce test unless he obtained 33% marks in each paper and 45% marks in aggregate. Q14 discuss the decision of Supreme Court in Indira Sawhney v. Union of India, AIR 1993 SC 477 so far as reservation of posts for backward classes in matters relating to public employment or appointment to any office under the state is concerned. Ans. The scope and extent of Article 16(4) has been examined thoroughly by the Supreme Court in the historic case of Indira Sawhney v. Union of India, AIR 1993 SC 477, popularly known as the Mandal case. The facts of the case were as follows. On 1st January 1979, the government headed by the Prime Minister Shri Morarji Desai appointed the Second Backward Classes Commission under Article 340 of the Constitution under the chairmanship of Shri B.P. Mandal, MP, to investigate the socially and educationally backward classes within the territory of India and recommended steps to be taken for their advancement, including desirability for making provisions for reservation of seats for them in government jobs. The Commission submitted its report in December 1980. It had identified as many as 3,743 castes as socially and educationally backward classes and recommend for reservation of 27% government's jobs for them. In the meantime, the Janata government collapsed due to internal dissensions, and the Congress party headed by the Prime Minister SMT Indira Gandhi came to power at the centre. The Congress government did not implement the Mandal Commissioner report till 1989. In 1989, the Congress party was defeated in the parliamentary elections, and the Janata Dal again came to power and decided to implement the Commission's report as it had promised to the electorate. Accordingly, the Government of India, headed by Prime Minister Shri V.P. Singh, issued the Office Memoranda, called OM. On 13 August 1990, reserving 27% seat for backward classes in government services on the basis of the recommendations of the Mandal Commission. The acceptance of the report of the Mandal Commission threw the nation into turmoil, and a violent anti-reservation movement rocked the nation for nearly 3 months, resulting in huge loss of persons and property. A writ petition on behalf of the Supreme Court Bar Association was filed challenging the validity of the OM and for staying its operation. The 5 judges bench of the court stayed the operation of the OM till the final disposal of the case on 1st October 1990. Unfortunately, the Janata government again collapsed due to defections, and in 1991 parliamentary elections the Congress party again came to power at the centre. The Congress party government headed by Shri P.V. Narasimha Rao issued another office memoranda on 25 September 1991 but made 2 changes in the OM of Janata Dal government issued on 13 August 1990. By introducing the economic criterion in granting reservation by giving preference to the poorer sections of SEBCs in the 27% quota, and 2. Reserved another 10% of vacancies for other socially and educationally backward classes, SEBCs, economically backward sections of higher castes. The economic criterion was to be specified separately. The 5 judges bench referred the matter to a special constitution bench of 9 judges in view of the importance of the matter to finally settle the legal position relating to reservations, as in several earlier judgments the Supreme Court have not spoken in the same voice on this issue. Despite several adjournments, the Union government failed to submit the economic criteria as mentioned in Official Memorandum of 25 September 1991. The 9 judges Constitution Bench of the Supreme Court, by 6-3 majority, Justice B.P. Jeevan Reddy, C.J., M.H. Kanya, M.N. Venkatachalya, M. Ahmadi with S.R. Pandian, and S.B. Sawant concurring by separate judgments held that the decision of the Union government to reserve 27% government jobs for backward classes provided socially advanced persons creamy layer among them are eliminated, is constitutionally valid. The reservation of seats shall only confine to initial appointments and not to promotions, and the total reservation shall not exceed 50%. The court accordingly partially held the 2 impugn notifications, OM, dated 13 August 1990 and 25 September 1991 as valid and enforceable, but subject to the condition that socially advanced persons creamy layer among B.Cas are excluded. However, the court struck down the Congress government's on reserving 10% government jobs for economically backward classes among higher classes. The majority decision of the Supreme Court on various aspects of reservations provided in Article 16(4) may be summarized as follows. 1. The majority held that a caste can be, and quite often is, a social class in India, and if it is backward socially, it would be a backward class for the purpose of Article 16(4). 2. Article 16(4) is not an exception to Article 16(1). It is an instance of classification. Hence, reservation can be made under Article 16(1). 3. The majority held that the backward class of citizens contemplated in Article 16(4) is not the same as socially and educationally backward classes in Article 15(4). 4. The majority held that while identifying the backward classes, the socially advanced persons, the creamy layer, among them being excluded, for the purpose of giving benefit of reservation. 5. The majority held that Article 16(4) permits classification of backward classes into backward and more backward classes, for the purpose of giving more protection to more backward class people. 6. The majority held that a backward class of citizens cannot be identified only and exclusively with reference to economic criteria. 7. The majority held that the maximum limit of reservation cannot exceed 50%. However, in extraordinary situations, it may be relaxed in favor of people living in remote, far-flung areas of the country. 8. The majority held that reservation can be made by an executive order, if need be made by Parliament or state legislature. 9. The majority held that the reservation under Article 16(4) cannot be made in promotions. The reservation is confined to initial appointments. 10. The court directed the Union government, state governments, and union territories to appoint a permanent statutory body to examine complaints of wrong inclusion or non-inclusion of groups, classes and sections in the list of other backward classes. 11. The majority made it clear and directed that all objections to the criteria evolved by the central government and state government to exclude socially advanced persons creamy layer from other backward classes shall be filed only before the Supreme Court and not before any High Court or tribunal. Q. 15. What is a law relating to titles and presents? Can an Indian citizen accept titles or presents from foreign powers? Does contravention of Article 18 entails any liability? Ans. Article 18 relates to titles. It runs as follows. 1. No title, not being a military or academic distinction, shall be conferred by the state. 2. No citizen of India shall accept any title from any foreign state. 3. No person who is not a citizen of India shall, when he holds any office of profit or trust under the state, accept without the consent of the President any title from any foreign state. 4. No person holding any office of profit or trust under the state shall, without the consent of the President, accept any present, emolument, or office of any kind from or under any foreign state. Indian citizens cannot accept any title from a foreign state. The restriction in this respect is absolute, but an Indian citizen can, however, accept a present from a foreign state, but only with the consent of the President. So far as foreigners holding any office of profit and trust under the state are concerned, they can accept both the titles and presents, but after obtaining the consent of the President. The recent conferment of titles as Bharat Ratna, Padma Vibhushan, etc. are not prohibited under Article 18. Therefore, they do not fall within the prohibition. It will be noted that there is no penalty prescribed for infringement of the above prohibition. However, it is open to Parliament to penalize by appropriate law the persons who accept titles in violation of Article 18. In a significant case in Balaji Raghavan v. Union of India, 1996, 1 SCC 361, the petitioners challenged the validity of these national awards and requested the court to prevent the Government of India from conferring these awards. It was contended that the national awards are titles within the meaning of Article 18 of the Constitution. It was also argued that these awards are being grossly misused and the purpose for which they were instituted has been diluted and they are granted to persons who are undeserving of them. The Supreme Court held that the national awards such as Bharat Ratna, Padma Bhushan, and the Padma Shri are not violative of the principle of equality as guaranteed by the provisions of the Constitution. The national awards do not amount to titles within the meaning of Article 18 and, therefore, not violative of Article 18 of the Constitution. Q. 16. What freedoms are guaranteed by the Indian Constitution? Are such freedoms exhaustive? Discuss if such freedoms are absolute rights and if not, discuss the need for limiting them. Ans. Right to freedom. The Article 19 to 22 deals with different aspects of this basic right. Article 19 guarantees to the citizen of India the 6 fundamental freedoms which are exercisable by them throughout and in all part of the territory of India. These are A. Freedom of speech and expression, B. Freedom of assembly, C. Freedom of association, D. Freedom of movement, E. Freedom of residence and settlement, F. Omitted by 44th Amendment, G. Freedom of profession, occupation, trade or business. These freedoms are, however, not absolute. The clauses 2 to 6 of Article 19 recognize the right of the state to make laws putting reasonable restrictions for the reasons set out in those subclauses. The restrictions which may be imposed under any of the clauses must be reasonable restrictions. Hence, a law restricting the exercise of any of the 6 freedoms guaranteed by Clause 1 of Article 19 to be constitutionally valid must satisfy 2 conditions. I. The restriction must be for the particular purpose mentioned in the clause permitting the imposition of the restriction on that particular right, and 2. The restriction must be a reasonable restriction. Reasonable restrictions. The Supreme Court has laid down the guidelines for determining the reasonableness of restrictions, which are as follows. It is the courts, and not the legislature, which has to judge finally whether a restriction is reasonable or not. The term reasonable restriction in Article 19, 6 connotes that the limitation imposed on a person in the enjoyment of his right should not be arbitrary or of an excessive nature, beyond what is actually required in the interest of the public. The expression seeks to strike a balance between the individual rights guaranteed by Article 19 and social control permitted by clauses 2 to 6 of Article 19. Therefore, the restriction must have a reasonable relation with the object which the legislation seeks to achieve and must never exceed it. There is no definite or absolute test to judge the reasonableness of a restriction. Each case is to be judged on its own merits. The following factors have to be taken into consideration for any judicial verdict. A. The nature of the right infringed. B. The underlying purpose of the restrictions imposed. C. The extent and urgency of the civil wrongs to be remedied. D. The disproportion of the imposition. E. The prevailing conditions at that time. The restriction must be reasonable from the substantive as well as procedural standpoint. A restriction which is imposed for securing the objects laid down in the directive principles of state policy may be regarded as reasonable restriction. Hanif Qureshi v. State of Bihar, AIR 1958 SC 731. The court must determine the reasonableness of a restriction by objective standard and not by subjective one. In other words, the question is not if the court feels the restriction to be reasonable, but where a normal reasonable man would regard the restriction to be reasonable. It is the reasonableness of the restriction which is to be determined by the court, and not the reasonableness of the law. Restriction may also amount to prohibition under certain circumstances. The rights guaranteed by Article 19 are available only to citizens and not to an alien or a foreigner. Citizens under Article 19 mean only natural persons and not legal persons such as corporations or companies. The only of proving to the satisfaction of the court that the restriction is reasonable is upon the state. The harder the restriction, the heavier the onus to prove the reasonableness. Q. 17 discuss the scope of the freedom of speech and expression. Does it include freedom of press also? It is an absolute right. Ans. Freedom of speech and expression is a bulwark of a democratic form of government. Article 19, 1. A. Guarantees to all citizens the right to freedom of speech and expression. According to Article 19, 2. The state may make a law imposing reasonable restrictions on the exercise of that right in the interests of the security of state, friendly relations with foreign states, public order, decency or morality, contempt of court, defamation, incitement to an offense, or sovereignty and integrity of India. Any limitation on the exercise of the fundamental right under Article 19, 1. A. Not falling within the four corners of Article 19, 2. Cannot be valid. Meaning and scope. Freedom of speech and expression means the right to express one's own convictions and opinions freely by words of mouth, writing, printing, pictures, or any other mode. It thus includes the expression of one's ideas through any communicable medium or visible representation, such as gesture, signs, and the like. The expression connotes also publication, and thus the freedom of the press is included in this category. Free propagation of ideas is the necessary objective, and this may be done on the platform or through the press. The freedom of propagation of ideas is secured by freedom of circulation. Liberty of circulation is essential to that freedom as the liberty of publication. Indeed, without circulation the publication would be of little value. The freedom of speech and expression includes liberty to propagate not one's views only. It also includes the right to propagate or publish the views of other people, otherwise this freedom would not include the freedom of the press. Freedom of expression has four broad special purposes to serve. 1. It helps an individual to attain self-fulfillment. 2. It assists in the discovery of truth. 3. It strengthens the capacity of an individual in participating in decision-making, and 4. It provides a mechanism by which it would be possible to establish a reasonable balance between stability and social change. All members of society should be able to form their own beliefs and communicate them freely to others. In Union of India v. Association for Democracy Reforms, AIR 2002 SC 2112, the Supreme Court has held that the voters have fundamental right to know about antecedents of candidates contesting election. Democracy cannot survive without free and fair election, without free and fairly informed voters. Votes cast by uninformed voters in favor of a candidate would be meaningless. In the instant case, the petitioners for democratic reforms filed a public interest litigation and for direction to implement the recommendations made by the Law Commission in its 170th report. Freedom of press. The Constitution does not contain any specific provision ensuring freedom of the press, which has therefore to depend on Article 19, 1a. In Ramesh Thapar v. State of Madras, AIR 1950 SC 124, the Supreme Court held that the freedom of speech and expression includes freedom of propagation of ideas, which freedom is ensured by the freedom of circulation of a publication, for without circulation, the publication would be of little value. The Supreme Court therefore held in this case that a ban authorizing the government to impose a ban upon entry and circulation of a journal in a state is restrictive of freedom of speech and expression, and it can be valid only if it falls within Article 19, 2. Explaining the concept of freedom of press, the Supreme Court stated in Express Newspaper v. Union of India, AIR 1958 SC 578, that no law could be enacted having the effect of imposing a pre-censorship, curtailing the circulation, restricting the choice of employment or unemployment in the editorial force, preventing newspapers from being stated or undermining its independency by driving the press to seek government aid to survive. In this case, Supreme Court was called upon to adjudge the validity of the Working Journalist Act, 1955, enacted by Parliament to regulate certain conditions of service of persons employed in newspaper establishment, i.e. the payment of gratuity, hours of work, leave, fixation of wages, etc. The ground of challenge before the court was that it would adversely affect the financial position of the marginally situated newspaper, which might be forced to go out of circulation, and thus the tendency of the Act was to curtail circulation and thereby to narrow the scope of dissemination of information. The court held the Act valid as it did not take away the right of freedom of speech and expression enjoyed by the petitioners under Article 19, 1a. In Prabhu Dutt v. Union of India, AIR 1982 SC 6, the Supreme Court has held that the right to know news and information regarding administration of the governments is included in the freedom of press. But this right is not absolute, and restrictions can be imposed on it in the interest of society and the individual from which the press obtains the information. They can obtain information from an individual when he voluntarily agrees to give such information. In the instant case, the court directed the superintendent of the Tihar jail to permit the chief reporter of the Hindustan Times newspaper to interview Ranga and Billa, the two death sentence convicts, under Article 19, 1a, as they were willing to be interviewed. The jail authorities had refused the permission to the newspaper representative to interview the convicts. Imposition of pre-censorship on press. Pre-censorship is unconstitutional. The Supreme Court in Brij Bhushan v. State of Delhi, AIR 1950 SC 129, held that the imposition of censorship on a journal previous to its publication would amount to an infringement of Article 19, 1a. In Bennett Coleman and Co. v. Union of India, AIR 1973 SC 106, the court held that the newsprint policy is not reasonable restriction within the ambit of Article 19, 2. The newsprint policy abridges petitioners' rights of freedom of speech and expression. In Express Newspapers, PVT, Limited v. Union of India, AIR 1986 SC 872, it has been held that the notices of re-entry upon forfeiture of lease and the threatened demolition of the Express building are intended to silence the voice of Indian Express and therefore violative of Article 19, 1a of the Constitution. In K. Abbas v. Union of India, AIR 1971 SC 481, it has been held that the pre-censorship of films is justified under Article 19. 2. On the ground films have to be treated differently from other forms of art and expression because of its instant effect on persons who watch it, particularly on adolescents. Grounds of restrictions. The following are the grounds of restrictions on the freedom of speech and expression as has been mentioned in Article 19(2) of the Constitution. A. Security of the state. B. Friendly relations with foreign states. C. Public order. D. Decency or morality. E. Contempt of court. F. Defamation. G. Incitement to an offense. H. Integrity and sovereignty of India. A. Security of the state. In the interest of the security of state, reasonable restriction under Article 19(2) can be imposed on the freedom of speech and expression of a citizen. In State of Bihar v. Shashibala Devi, AIR 1952 SC 329, the Supreme Court has held that the term security of state means only to serious and aggravated forms of public disorder like rebellion or waging war against Indian government. B. Friendly relations with foreign states. The object behind this provision is to prohibit unrestrained malicious propaganda against a foreign friendly country, which may jeopardize the maintenance of good relations between India and that state. In India, the Foreign Relations Act, 12 of 1932, provides punishment for libel by Indian citizens against foreign dignitaries. But the interest of friendly relations with foreign states would not justify the suppression of fair comment of foreign government. C. Public order. Public order means and includes absence of direct intention to lead disorder as well as the absence of tendency to lead disorder. A law punishing these disorderly acts is valid as it restricts the right relating to free speech in the interest of public order. In Kishori Mohan v. State of West Bengal, AIR 1972 SC 1749, the Supreme Court has held that every infraction of laws must necessarily affect order but not necessarily public order, and an act may affect public order but not necessarily security of state. D. Decency or morality. Sections 290 to 294 of IPC provide instances of restrictions of freedom of speech and expression in the interest of decency and morality. But it does not lay down any test for determining the obscenity. In Ranjit Udeshi v. State of Maharashtra, AIR 1965 SC 881, the Supreme Court followed the test laid down in English case of R. V. Hicklin LR 3QB 360 and held that the novel Lady Chatterley's Lover was an obscene book, as it had tendency to corrupt the mind of those who read it. E. Contempt of court. Articles 125 and 215 of the Constitution authorize the Supreme Court and the High Court respectively to punish for their contempt. In C.K. Daftari v. O.P. Gupta, AIR 1971 SC 1132, the Supreme Court ruled that a law relating to contempt imposes reasonable restrictions on the right guaranteed by Article 19(1)(a). F. Incitement to an offense. The right to freedom of speech and expression does not give permission to citizens to incite a person to commit an offense. The freedom will be curtailed on this ground and incitement to an offense is made punishable by law. G. Defamation. Sections 499 and 500 of IPC define defamation, which means exposing a man to hatred, contempt or ridicule. These sections are constitutional as they impose reasonable restrictions on the freedom of speech and expression. H. Integrity and sovereignty of India. The right to freedom of speech and expression can be restricted so as not to permit anyone to challenge the integrity and sovereignty of India or to preach, cession of any part of India from the Indian Union. Accordingly, Section 124- of IPC, which punishes the crime of waging war against the state, has been upheld as constitutional under this clause. Q18 discuss the freedom to assemble peaceably and without arms, as provided you Article 19(1) of the Constitution. What are the limitations on this freedom? Ans. Freedom of assembly. Article 19(1)(b) guarantees to all citizens of India right to assemble peaceably and without arms. The right of assembly includes the right to hold meetings and to take out processions. This right is, however, subject to the following restrictions. 1. The assembly must be peaceable. 2. It must be unarmed. 3. Reasonable restrictions can be imposed under Clause 3 of Article 19. The right of assembly is implied in the very idea of the democratic government. The right of assembly thus includes right to hold meetings and to take out processions. This right, like other individual rights, is not absolute but restrictive. The assembly must be non-violent and must not cause any breach of public peace. If the assembly is disorderly or riotous, then it is not protected under Article 19(1)(b), and reasonable restrictions may be imposed under Clause 3 of Article 19 in the interest of sovereignty and integrity of India or public order. When a lawful assembly becomes unlawful. Article 19(1)(b) says existing Indian law regulating public meetings in the interest of public order if the restrictions are reasonable. If an assembly becomes unlawful, it can be dispersed. Chapter 8 of the Indian Penal Code lays down the conditions when an assembly becomes unlawful. Under Section 141 of the Indian Penal Code, as assembly of 5 or more persons becomes an unlawful assembly if the common object of the persons composing assembly is a. To resist the execution of any law or legal process. b. To commit any mischief or criminal trespass. c. Obtaining possession of any property by force. d. To compel a person to do what he is not legally bound to do or omit which he is legally entitled to do. e. To overawe the government by means of criminal force or show of criminal force or any public servant in the exercise of his lawful powers. An assembly which was not unlawful when assembled may subsequently become unlawful if it becomes violent or is likely to result in disturbance. Under Section 129 of the Criminal Procedure Code, 1973, such an assembly may be ordered to be dispersed if the disturbance to the public peace is reasonably apprehended. Section 151 of the Indian Penal Code makes it an offence not to disperse after a lawful command to disperse has been given. Section 107 of the Criminal Procedure Code empowers magistrate to obtain security for keeping the peace from any person who is likely to commit a breach of peace. Section 144, Criminal Procedure Code, 1973 empowers the magistrate to restrain an assembly, meeting or procession if there is a risk of obstruction, annoyance or injury to any person lawfully employed or danger to human life, health or safety or a disturbance of the public tranquility or a riot or any affray. In Kameshwar Prasad v. State of Bihar, AIR 1960 to SC 1166, it was observed that broadly stated a demonstration is a visible manifestation of the feelings or sentiments of an individual or a group. It is a communication of one's ideas to other to whom it is intended. There are forms of demonstration which would fall within the freedom guaranteed by Article 19(1)(a) and 19(1)(b). A violent and disorderly demonstration would not obviously be within Article 19(1)(a) or (b). but peaceful and orderly demonstration would fall within the freedoms guaranteed under these clauses. Q19. Write a short note on the right to form unions and associations. Is this right an absolute right? Discuss the restrictions imposable on this right. Ans. Article 19, 1c guarantees to all citizens the right to form associations or unions. The right to form associations or unions is subject to the restrictions as laid down in subclause 4 of the said article. Subclause 4 says that nothing in subclause c of the said clause shall affect the operation of any existing law insofar as it imposes or prevents the state from making any law imposing in the interest of the sovereignty and integrity of India, or public order, or morality, reasonable restrictions on the exercise of the right conferred by the said subclause. Thus, restrictions can be imposed on the exercise of the right to form union and associations on the ground of safeguarding public order or morality and integrity and sovereignty of India. In Damayanti v. Union of India, AIR 1971 SC 966, the validity of Hindi Sahitya Sammelan Act 1962 was challenged as violative of Article 19, 1c. The petitioner was a member of an association. The Act changed the composition of the association and introduced new members. The result of this alteration was that the members who voluntarily formed the association were now compelled to act in the association with other members in whose admission they had no say. The Supreme Court held that the Act violated the rights of the original members of the society to form an association guaranteed under Article 19, 1c. The right to form an association, the court said, necessarily implies that the persons forming the association have also the right to continue to be associated with only those whom they voluntarily admit in the association. Any law by which members are introduced in the voluntary association without any option being given to the members to keep them out, or any law which takes away the membership of those who have voluntarily joined it, will be a law violating the rights to form an association. In OK Nair v. Union of India, AIR 1976 SC 1179, the appellants were members of the civil employees' unions in the various centers of the defense establishments. The commandant declared their unions as unlawful association. They challenged the validity of the impugned order on the ground that the said order was violative of Article 19, 1c. The Supreme Court held that the civil employees of the defense establishments answer the description of the members of the armed forces within the meaning of Article 33, and therefore they are not entitled to form trade unions. Restrictions on the freedom of association. The right of the association, like other individual freedom, is not unrestricted. Clause 4 of Article 19 empowers the state to impose reasonable restrictions on the right of freedom of association and union in the interest of public order or morality or sovereignty or integrity of India. It saves existing laws insofar as they are not inconsistent with fundamental rights of association. In Balkotia v. Union of India, AIR 1958 SC 230, to the services of the appellant were terminated under railway services rules for his being a member of Communist Party and trade unionist. The appellant contended that the termination from service amounted in substance to a denial to him right to form association. It was held that appellant had no doubt had fundamental right to form association, but he had no fundamental right to be continued in the government services. Therefore, order terminating his services was not in contravention of Article 19, 1c, because the order did not prevent the appellant from continuing in Communist Party and trade union. Q20 writ a short note on the right to move freely throughout the territory of India. What restrictions can be imposed on the said right? Ans. Article 19, 1d guarantees to all citizens of India the right to move freely throughout the territory of India. This right is, however, subject to reasonable restrictions mentioned in Clause 5, Article 19I, in the interest of general public or for the protection of the interests of any scheduled tribe. Article 19, 1d of the Constitution provides the citizens a right to go wherever they like in Indian territory without any kind of restriction whatsoever. They can move from one state to other and also from one place to another place within any state of India. This freedom cannot be curtailed by any law except within the limits of Article 19, 5. In this way, Constitution stresses that the entire country is one unit so far the citizens are concerned. The object is to create the sense of nationality in the minds of the citizens. Grounds of restrictions. The state under Clause 5 of Article 19 may impose reasonable restrictions on the freedom of movement on two grounds. 1. In the interest of general public. 2. For the protection of interest of any scheduled tribe. In N.B. Khare v. State of Delhi, AIR 1950 SC-11, the petitioner was served with an order of externment to remove himself from Delhi for a period of 3 months. The petitioner contended that the order imposed unreasonable restrictions on his right guaranteed under Article 19, 1d because 1. The issue of the order depended on the subjective consideration of the executive, and 2. The act under which the order was made did not prescribe any time beyond which the order could not continue. Accordingly, it was held by the Supreme Court that the mere fact that the order depended on the subjective considerations of the executive did not make the restriction unreasonable because the desirability of passing such an order in emergency has to be left to an officer. Secondly, as the act itself was of a limited duration, there was no possibility of an order being made for indefinite period. In state of HPV, Umad Ram Sharma, AIR 1986 SC 847, it was observed that every person is entitled to life as enjoined in Article 21 of the Constitution, and in the facts of this case read in conjunction with Article 19, 1d, to move freely throughout the territory of India, and he has also the right under Article 21 to his life, and that right Article 21 embraces not only physical existence of life, but the quality of life. Accordingly, there should be road for communication in reasonable conditions in view of our constitutional imperatives, and denial of that right would be denial of the life as understood in its richness and fullness by the ambit of the Constitution. To residents of the hilly areas so far as feasible and possible, society has constitutional obligation to provide road for communications. In state of UP v. Kaushalya, AIR 1964 SC 416, it was held that the right of movements of prostitutes may be restricted on the grounds of public health and in the interest of public morals. In Raja Sukhandas v. State of UP, AIR 1974 All 498, the validity of Section 3 of the UP Control of Gundas Act 1970 was challenged. The Supreme Court, while upholding the validity of the said section of UP Gundas Act, observed that the purpose of the Act was to control nefarious activities of the unsocial elements, and the Act defined the word Gundas, which showed that it covered only such persons who carried on activities which were against the interest of the general public and therefore be prohibited under Clause 5 of Article 19. Restrictions on the right of movement for the protection of the interest of the scheduled tribe is based on the fear that uncontrolled mixing of the tribe with the people of other areas might produce undesirable effect upon the tribal people. Q21 discuss the right of residence and settlement guaranteed to a citizen under the Constitution. Discuss the restrictions that can be imposed on this right. Ans. According to Article 19(1)(e), Indian citizens have the right to reside and settle in any part of India. According to Clause 5 of Article 19, however, reasonable restrictions can be imposed on this right by law by the state in the general interests of the general public or for the protection of interests of any scheduled tribe. The right of movement and residence go together, for when a person is asked to quit a particular place, both of his rights of movement and residence are affected. Therefore, in matters of restrictions imposed on the citizens regarding movement or residence at a particular place within the country, the same principles are followed, and most of the cases considered under Article 19(1)(d) are also relevant to Article 19(1)(e). The freedom to reside and settle may be curtailed and suspended during an emergency. In Ibrahim Wazir v. State of Bombay, AIR 1954 SC-99, the appellant, an Indian citizen, came to India without permit and was arrested and deported to Pakistan by the government under the Influx from Pakistan Control Act 1949. It was held that the order of removal was invalid as coming a citizen to his home country without a permit was not an offence which would justify his expulsion from the country. In State of Madhya Pradesh v. Bharat Singh, AIR 1967 SC 1170, Section 3(1)(b) of the MP Public Security Act 1959 empowered the state government to issue an order requiring a person to reside or remain in such a place as may be specified in the order, to ask him to leave the place to go to another place selected by the authorities in the interests of security of the state or public order. The Supreme Court held that the impugned Section 3(1)(b) of the Act imposes unreasonable restriction on the right guaranteed by Article 19(1)(e) and therefore void. The Act did not give any opportunity to be heard to the concerned person about the place where he was asked to reside. Further, the section did not indicate the extent of the place, area or its distance from the residence of the person externed. Q20 to discuss the scope and extent of freedom of profession, trade and business guaranteed by Article 19(1)(g) of the Constitution. Ans. Article 19(1)(g) guarantees that all citizens shall have the right to practice any profession or to carry on any occupation, trade or business. However, the right to carry on a profession, trade or business is not unqualified. It can be restricted and regulated by authority of law. Thus, the state can under Clause 6 of Article 19 make any law a. imposing reasonable restriction on this right in the interest of public, b. prescribing professional or technical qualifications necessary for practicing any profession or carrying on any occupation, trade or business, c. enabling the state to carry on any trade or business to the exclusion of citizens wholly or partially. In Sukumar Mukherjee v. State of WB, 1993, 3 SCC 724, the appellants challenged the validity of West Bengal State Health Service Act 1990 on the ground that it imposes unreasonable restriction on their right to carry on any occupation, trade or business under Article 19(1)(g) of the Constitution. Section 9 of the Act prohibited private practice by teacher doctors of WB Medical Education Service and not by the doctors of WB Health Service. When these services were separated, the doctors were given an option to join either the WBMES or WBHS. It was held that the restriction imposed by Section 9 is reasonable and in the interest of the general public. The restriction is not on the freedom to practice the medical profession. This applies to those doctors who voluntarily join the government service. Those who join the government service are bound by the terms and conditions of service and will have no right to private practice. In Kerala SMT Feb v. Kerala TBO Association, 1994, 5 SCC 28, the validity of two orders made by the Government of Kerala under Section 4 of the Kerala Marine Fishing Regulation Act, 1980 was challenged by the owners and operators of mechanized boats as violative of their rights to move freely under Article 19(1)(g), which includes territorial waters. By these orders, bottom trawling was prohibited altogether within the territorial waters for a period of 44 days monsoon period in the year 1992, and thus their boats were practically confined to the seashore during this period and not to go to sea. The object of this order was to protect the interests of the larger sections of the fishermen and assuring livelihood of traditional fishermen and also conservation of fish wealth and to avoid possible law and order problem in coastal area and the sea. The court held that the two orders were valid as they imposed reasonable restrictions in public interest. In a significant judgment in Dr. Haniraj L. Chauhani v. Bar Council of Maharashtra in Goa, 1996, 3 SCC 340 to the Supreme Court has upheld the validity of a rule of State Bar Council of Maharashtra and Goa, which restricted entry of other professionals into legal profession while they are already carrying any other full-time profession. The right to practice any profession or to carry on any occupation, trade or business is not an absolute right, but subject to reasonable restrictions specified in Clause 6 of Article 19. The appellant, who was a doctor, had applied for enrollment as an advocate. The rule made by the Bar Council prevented him from being enrolled as an advocate. The appellant challenged the validity of the rule on the ground that it was violative of his fundamental right under Art 19(1)(g) of the Constitution. The appellant claimed that even though he is medical practitioner, he was entitled to simultaneously carry on the profession as an advocate. The Supreme Court held that the State Bar Council was justified in framing the impune rule prohibiting the entry of a professional who insists on carrying on other profession. The judges observed, the legal profession required full attention and would not countenance an advocate riding two horses or more at a time. He has to be a full-time advocate or not at all. In MS BR Enterprises v. State of UP, AIR 1999 SC 1867, the petitioners had challenged the validity of Lotteries Regulation Act 1988 and the order passed by the State of UP in exercise of power vested under Section 5 of the Act banning sale of lottery tickets of other states in the state of Uttar Pradesh as violative of Article 19(1)(g) and Articles 301, 302, and 303 of the Constitution. The Supreme Court, however, has held that lottery contains an element of chance and therefore cannot be trade or commerce but is gambling. Sale of lottery tickets organized by the state cannot be construed to be trade and commerce within the meaning of Articles 301 to 303 or trade or business under Article 19(1)(g) of the Constitution. The constitution makers could never have conceived to give protection to gambling either under Article 19(1)(g) or as trade under Article 301 of the Constitution. The difference between gambling and trade is that a gambling inherently contains a chance with a no skill, while trade contains skill with no chance. What makes lottery a pernicious is its gambling nature. Even in the state-run lotteries, the same elements of chance remains with no skill. Accordingly, the court held that the ban imposed by the state of Uttar Pradesh on the sale of lotteries is constitutional and not violative of Article 19(1)(g) of the Constitution. Q23. Write a short note on following. A. Protection against Ex-Post Facto Law. B. Protection against Double Jeopardy. C. Prohibition against Self Incrimination. Ans. A. Protection against Ex-Post Facto Law. The Clause 1 of Article 20 provides protection to the persons accused of crimes against ex-post facto law. It prohibits the legislature to make retrospective criminal laws. The first part of Clause 1 provides that no person shall be convicted of any offence except for violation of law in force at the time of the commission of the act charged as an offence. This means that if an act is not an offence at the date of its commission, it cannot be an offence at the date subsequent to its commission. The protection afforded by Clause 1 is available only against conviction or sentence for a criminal offence under ex post facto law and not against the trial. The protection of Clause 1 of Article 20 cannot be claimed in case of preventive detention or demanding security from a person. The prohibition is just for conviction and sentence only and not for prosecution and trial under a retrospective law. The second part of Clause 1 protects a person from penalty greater than which he might have been subjected to at the time of the commission of the offence. But the accused can take advantage of the beneficial provisions of the ex post facto law. The rule of beneficial interpretation required that ex post facto law, when is beneficial to the accused, is not prohibited by Clause 1 of Article 20. In Shiv Bahadur Singh v. State of UP, AIR 1953 SC 394, it was observed that what is prohibited u Article 20 is only conviction or sentence under an ex post facto law and not the trial thereof, such trial under a procedure different from what obtained at the time of the commission of the offence or by a court different from that which had competence at the time cannot ipso facto be held to unconstitutional. Article 21, in its broad import, has been enacted to prohibit convictions and sentences under ex post facto laws. This article must be taken to prohibit all convictions or subjections to penalty after the Constitution in respect of ex post facto law, whether the same was a post-Constitution law or a pre-Constitution law. In G.P. Nair v. State, Delhi Ann. AIR 1979 SC 602 Article 21 deals with the ex post facto laws, though that expression has not been used in the article. Though sovereign legislature has power to legislate retrospectively, creation of an offence for an act which at the time of its commission was not an offence or imposition of a penalty greater than that which was under the law provided violates Article 21. All that Article 21 prohibits is ex post facto law and is designed to prevent a person being punished for an act or omission which was considered innocent when done. It only prohibits the conviction of person or his being subjected to a penalty under ex post facto laws. B. Protection against Double Jeopardy. Clause 2 of Article 20. The Clause 2 provides protection to the accused persons against double jeopardy. The Clause 2 declares that no person shall be prosecuted and punished for the same offence more than once. This clause embodies the common law rule of memo debs, vis vexari, which means that no man should be put twice in peril for the same offense. If he is prosecuted again for the same offense for which he has already been prosecuted, he can take complete defense of this former acquittal or conviction. Article 22 embodies the following essentials for the application of double jeopardy rule. 1. The person must be accused of an offense. The word offense as defined in General Clauses Act means any act or omission made punishable by law for the time being in force. 2. The proceeding or the prosecution must have taken place before a court or judicial tribunal. 3. The person must have been prosecuted and punished in the previous proceeding. 4. The offense must be the same for which he was prosecuted and punished in the previous proceedings. Proceedings before departmental and administrative authorities cannot be a proceeding of judicial nature. The clause 2 of Article 20 does not apply where the person is prosecuted and punished for the second time and subsequent proceeding is a mere continuation of the previous proceeding. Example, in the case of an appeal against acquittal. In Venkataraman v. Union of India, AIR 1954 SC 375, it was observed that the roots of the principle which Article 22 enacts are to be found in the well-established rule of English law, which finds expression in the maxim, nemo debet bis vexari, a man must not be put twice in peril for the same offense. If a man is indicted again for the same offense in an English court, he can plead as a complete defense his former acquittal or conviction, or as it is technically expressed, take the plea or autrefois acquit or autrefois convict. In Maqbool Hussain v. State of Bombay, AIR 1953 SC 325, it was observed that in order to invoke the protection of Article 22, there must have been a prosecution and punishment in respect of the same offense before a court of law or judicial tribunal, required by law to decide the matters in controversy, judicially on evidence on oath which it must be authorized by law to administer, and not before a tribunal which entertains a departmental or administrative enquiry, even though set up by a statute, but not required to proceed on legal evidence given on oath. The article contemplates proceedings of the nature of criminal proceedings before court of law or a judicial tribunal, and the prosecution in this context means initiation of proceedings of a criminal nature before such a court or tribunal in accordance with the procedure prescribed in the statute which creates the offense and regulated the procedure. In Venkataraman v. Union of India, Supra, it was observed that the language of Article 20 and the words actually used in Article 22 afford a clear indication that the proceedings in connection with the prosecution and punishment of a person must be in the nature of criminal proceeding before a court of law or judicial tribunal, and not before a tribunal which entertains a departmental or administrative enquiry, even though set up by a statute, but which is not required by law to try a matter judicially and on legal evidence. In State of Bombay v. S.L. Apte, AIR 1961 SC 578, it was observed that if the offences were distinct, there is no question of the rule as to double jeopardy as embodied in Article 22 of the Constitution being applicable. Though S. 26 of the General Clauses Act, in its opening words, refers to the act or omission constituting an offence under two or more enactments, the emphasis is not on the facts alleged in the two complaints but rather on the ingredients which constitute two offences with which a person is charged. This is made clear by concluding portion of the section which refers to shall not be liable to be punished twice for the same offence. The above construction of Article 22 2 of the Constitution and S. 26 of the General Clauses Act is precisely in line with the terms of S. 403(2) of the Criminal Procedure Code. Where therefore the accused are sought to be punished for the offence under Section 105 Insurance Act, after their trial and conviction for the offence under S. 409 Penal Code, they are not being sought to be punished for the same offence twice, but for two distinct offences constituted or made up of different ingredients, and therefore the bar of Article 23 of the Constitution or of S. 26 of the General Clauses Act, 1897, is not applicable. C. Prohibition against self-incrimination Clause 3 of Article 20. The Clause 3 provides protection to the accused persons against self-incrimination. It provides prohibition against self-incrimination. Article 23 provides that no person accused of any offence shall be compelled to be a witness against himself. This guarantee extends to any person accused of an offence and prohibits all kinds of compulsion to make him witness against himself. In MP Sharma v. Satish Chandra, AIR 1954 SC 300, case the court observed that this right embodies the following essentials. 1. It is a right pertaining to a person who is accused of an offence. 2. It is a protection against compulsion to be a witness. 3. It is a protection against such compulsion relating to his giving evidence against himself. A person is said to be an accused person against whom a formal accusation relating to the commission of an offence has been levelled, which in normal course may result in his prosecution and conviction. It is not necessary that the actual trial or inquiry should have started before the court. In MP Sharma Satish Chandra case, it was held that a person whose name was mentioned as an accused in the FIR by the police, an investigation was ordered by the magistrate, could claim the protection of this guarantee. The protection under Article 23 covers not merely testimonial compulsion in a courtroom but also compelled testimony previously obtained and any compulsory process for production if evidentiary documents which are reasonably likely to support the prosecution against him. The compulsory taking of finger impressions or specimen handwriting of an accused would come within the mischief of Article 23. But in State of Bombay v. Kathi Kalu, AIR 1961 SC 1808, case the court held that when a person gives his finger impression or specimen writing or signature, though it may amount to furnishing evidence in the large sense, is not included within the expression to be a witness. Hence, neither seizures made under search warrant, nor the compulsory taking of photographs, fingerprints, or specimen writing of an accused would come within the prohibition of Article 23. What is forbidden under Article 23 is to compel a person to say something from his personal knowledge relating to the charge against him. The protection under Article 23 is available only against the compulsion of accused to give evidence against himself. But left to himself, he may voluntarily waive his privilege by entering into the witness box or by giving evidence voluntarily on request. Request implies no compulsion, therefore, evidence given on request is admissible against the person giving it. To attract the protection of Article 23, it must be shown that the accused was compelled to make the statement likely to be incrimination of himself. Q24 examine the scope of fundamental right to life and personal liberty under the Indian Constitution. Ans. Article 21 says that no person shall be deprived of his life or personal liberty except according to procedure established by law. Safety of life and liberty of person are the two most essential things in an ordered society. The Constitution assures them not only to Indian citizens but to all persons in India. It has not been left to the whim of the executive to rob a person of his personal liberty and put him in detention. As person may be put in custody, if the law warrants, and when he is so put, it should be in conformity with the procedure established by law. All the safeguards that the law prescribes to protect the liberty of person from being jeopardized should be available to a person before he is put in detention. Personal liberty. The word personal liberty under Article 21 imports wide interpretation. In A.K. Gopalan v. State of Madras, AIR 1960 SC 27, personal liberty was held to mean liberty of the physical body, example, freedom from arrest and detention from false imprisonment or wrongful confinement. It was said that the expression personal liberty was antithesis of physical restraint and preventive detention. But this restrictive meaning has not been accepted in the subsequent case Kharak Singh v. State of UP, AIR 1963 SC 1295. It was held that the expression life was not limited to bodily restraint or confinement to person only but something more than mere animal existence. In this case the petitioner, Kharak Singh, was charged in a dacoity case but was released as there was no evidence against him. The police opened a history sheet against him and he was kept in police surveillance which included secret picketing of his house by the police, domiciliary visits at nights and unification of his movement and activities. The Supreme Court held that the domiciliary visits by the police were an invasion on the petitioner's personal liberty. By the term, life as used here, means something more than mere existence. The inhibition against its deprivation extends to all those limits and faculties by which life is enjoyed. The court held that the unauthorized intrusion into a person's home and the disturbance caused to him is the violation of the personal liberty of an individual. Hence, the police regulation authorizing domiciliary visits was plainly violative of Article 21 as there was no law on which it could be justified and it must be struck down as unconstitutional. In Satwanath Singh v. Ast. Passport Officer, New Delhi, AIR 1967 SC 1836, the Supreme Court further extended the scope of this article and held that right to travel abroad was part of a person's personal liberty within the meaning of Article 21 of the Constitution. In this case, the petitioner, who was a citizen of India, had to travel frequently for business purposes. The government ordered him to surrender the passport, but the petitioner challenged it on the ground that the right to travel abroad and return to India was part of his personal liberty. The Supreme Court accepted the contention of the petitioner and held that the right to travel abroad was part of a person's personal liberty within the meaning of Article 21 and therefore no person can be deprived of his right to travel abroad except according to procedure established by law. In fact, there was no law on which the government could justify its action. Procedure established by law. The word law in Article 21 refers to law made by the state and not to positive law or law in the abstract sense, embodying the principle of natural justice, and procedure established by law means procedure established by law made by the state, that is to say, by the Union Parliament or the legislature of the state. The Supreme Court had held in Maneka Gandhi v. Union of India, AIR 1978 SC 597, wherein the petitioner's passport was impounded, that the government was not justified in withholding the reasons for impounding the passport from the petitioner. Delivering majority judgment, Justice Bhagwati asked, is the presentation of some sort of procedure enough, or must the procedure comply with any particular requirement? He then held the procedure contemplated in Article 21 could not be unfair or unreasonable. And this principle of reasonableness, which was an essential element of equality or non-arbitrariness, pervaded Article 14 like a brooding omnipresence, and the procedure contemplated in Article 21 must answer the test of reasonableness in order to be in conformity with Article 14. Hence, any procedure which permitted impairment of individuals' right to go abroad without giving him a reasonable opportunity to be heard could not but be condemned as unfair and unjust. The order withholding reasons for impounding the passport was therefore not only in breach of statutory provisions of Passport Act but also in violation of the rule of natural justice embodied in the Maxim Audi Alteram Partem. Although there are no positive words in the statute, Passport Act, requiring that the party shall be heard, yet the justice of the common law shall supply this omission of the legislature. The power conferred on the Passport Authority to impound the passport under Section 10(3)(c) of the Act was a quasi-judicial power. The rules of natural justice would therefore be applicable in the exercise of this power. Fairness in action, therefore, demands that an opportunity to be heard should be given to the person affected. Thus the court gave a new dimension to Article 21 in the Maneka Gandhi case. It held that the right to live is not merely confined to physical existence but it includes within its ambit the right to live with human dignity. Elaborating the same view, the court in Francis Corelli v. Union Territory of Delhi, AIR 1978 SC 597 said that the right to live is not restricted to mere animal existence. It means something more than just physical survival. The right to live is not confined to the protection of any faculty or limb through which life is enjoyed or the soul communicates with the outside world, but it also includes the right to live with human dignity, and all that goes along with it, namely, the bare necessities of life such as adequate nutrition, clothing and shelter and facilities for reading, writing and expressing ourselves in diverse forms, freely moving about and mixing and commingling with fellow human beings. Right to livelihood in Oliga Tills v. Bombay Municipal Corpo. AIR 1986 SC 185 Judge Bench of Supreme Court has finally ruled that the word life in Article 21 includes the right to livelihood also. The court said, it does not mean merely that life cannot be extinguished or taken away as, for example, by the imposition and execution of death sentence, except according to procedure established by law. That is but one aspect of the right to life. An equally important facet of that right is the right to livelihood, because no person can live without the means of livelihood. If the right to livelihood is not treated as a part of the constitutional right to life, the easiest ways of depriving a person of his right to life would be to deprive him of his means of livelihood. In view of the fact that Articles 30(a) and 41 require the state to secure to the citizen an adequate means of livelihood and the right to work, it would be sheer pedantry to exclude the right to livelihood from the content of the right to life. Similarly, in D.K. Yadav v. JMA Industries, 1993, 3 SCC 258 Supreme Court held that right to life enshrined under Article 21 includes right to livelihood, and therefore before terminating the service of an employee or workman, fair play requires that a reasonable opportunity should be given to him to explain his case. Right to shelter. In Chameli Singh v. State of UP, 1996, to SCC 549, it has been held that the right to shelter is a fundamental right under Article 21 of the Constitution. In any organized society, the right to live as a human being is not ensured by meeting only the animal needs of man. It is secured only when he is assured of all facilities to benefit himself. Right to live guaranteed in any civilized society implies the right to food, water, decent environment, education, medical care, and shelter. These are basic human rights known to any civilized society. Right to privacy. In our Rajagopal v. State of TN, 1994, 6 SCC 632 popularly known as Auto Shankar case, the Supreme Court has expressly held the right to privacy, or the right to be let alone, is guaranteed by Article 21 of the Constitution. A citizen has a right to safeguard the privacy of his own, his family, marriage, procreation, motherhood, childbearing, and education, among other matters. None can publish anything concerning the above matters without his consent, whether truthful or otherwise, and whether laudatory or critical. If he does so, he would be violating the right of the person concerned and would be liable to an action for damages. However, possession may be deferred if he voluntarily puts into controversy or voluntarily invites or raises a controversy. This rule is subject to an exception that if any publication of such matters are based on public record, including court record, it will be unobjectionable. Right to health and access to medical treatment. Of late, the right to health and access to medical treatment has been included in the plethora of rights brought under the ambit of Article 21. The attitude of judiciary in expanding the horizons of Article 21 has been analyzed with special reference to the right to health and medical assistance as a right under Article 21. In Vincent Panikurlanga v. Union of India, AIR 1987 SC 990, the Supreme Court held that a healthy body is the very foundation for all human activities. So, in a welfare state, it is the obligation of the state to ensure the creation and the sustaining of conditions congenial to good health. Further, in Parmanand Katara v. Union of India, AIR 1989 SC 2039, a petition was filed under Article 32 of the Constitution, when a private doctor refused to treat a patient who met with an accident because of non-compliance of procedural formalities regarding accident victims. The court ordered the medical institution to provide medical aid and treatment immediately, irrespective of whether the procedural formalities have been complied with. The observation in Parmananda Katara created a new right, the right to get medical aid, and it has become an integral part of Article 21 of the Constitution. This stand has been retreated by the Apex Court in Consumer Education and Research Centre v. Union of India, AIR 1995 SC 922. Right to end one's own life. The issue of attempt to commit suicide brought to life again. In 1994, this offence was declared void by the Division Bench of the Supreme Court P. Rathiram AIR 1994 SC 1844. The court then declared that Section 309 of Indian Penal Code, which provides punishment for an attempt to commit suicide, deserved to be effaced from the statute book to humanize our penal laws. But 2 years thereafter, the full bench of the Apex Court completely overruled the above principle in SMT Gyan Kaur v. State of Punjab case, AIR 1996 SC 1257, by holding that right to life is not like other fundamental rights such as the right to form, association, and speech, which are positive rights. Right to speech includes the right not to speak. The right to form association includes the right not to form association. But right to life does not include the right not to live. Thus, a 5-judge constitutional bench has set off a controversy on the legality of the right to life. Is it compulsory or optional? The court ruled it is compulsory. The state cannot bestow a right to die on the citizens. The state is constitutionally bound to protect a citizen's life, howsoever miserable it may be. In this context, Article 21 of the Constitution is its backbone. Right to education. the Supreme Court of India, by a process of judicial interpretation in Mohini Jain's case, AIR 1992 SC 1858, held that the right to education is a fundamental right under Article 21 of the Constitution, which cannot be denied to a citizen by charging higher fees known as capitation fees. Later on, the correctness of Mohini Jain's case was examined by the full bench of the Apex Court in Unnikrishnan v. State of AP, AIR 1993 SC 2178. The five-judge bench by 3-2 majority partly agreed with Mohini Jain decision and held that right to education is a fundamental right under Article 21 of the Constitution, as it directly flows from right to life. But as regards its content, the court partly overruled Mohini Jain case and held that the right to free education can be made available only to children until they complete the age of 14 years, but after that the obligation of the state to provide education is subject to the limits of its economic capacity and development. 86th Amendment Act has added a new Article 21- which makes the right of education of children of the age of 6 to 14 years a fundamental right. It also substitutes Article 45, which is as follows: the state shall endeavor to provide early childhood care and education for all children until they complete the age of 6 years. It also added a new fundamental duty to Part 4 of the Constitution: protection against illegal arrest, detentions, and custodial death in Joginder Kumar v. State of UP, 1994. 4 SCC 260. The Supreme Court has laid down guidelines governing arrest of a person during investigation. This has been done with a view to strike a balance between the needs of police on the one hand and the protection of human rights of citizens from oppression and injustice at the hands of law enforcing agencies. The court has held that a person is not liable to arrest merely on the suspicion of complicity in an offense. There must be some reasonable justification in the opinion of the police officer effecting the arrest that such arrest was necessary and justified. Following are the guidelines laid down by the court. 1. An arrested person being held in custody is entitled, if he so requests, to have one friend, relative or other person who is known to him or likely to have an interest in his welfare told as far as is practicable that he has been arrested and where is being detained. 2. Police officer shall inform the arrested person when he is brought to the police station of this right. 3. An entry shall be required to be made in the diary as to who was informed of the arrest. These protections from power flow from Article 21 and Article 22 of the Constitution, and therefore they must be enforced strictly. Prevention of sexual harassment of working women in a landmark judgment in Visakhapatnam v. State of Rajasthan, AIR 1997 SC 3011, the Supreme Court has laid down exhaustive guidelines to prevent sexual harassment of working women in places of their work until a legislation is enacted for the purpose. The court held that it is the duty of the employer or other responsible person in workplaces or other institutions, whether public or private, to prevent sexual harassment of working women. Ban on smoking in public places in Murli S. Deora v. Union of India, AIR 2002 SC 40. The petitioner filed a public interest litigation in the Supreme Court seeking order for banning smoking in public places. The court, considering the adverse effect of smoking on smokers and other persons, directed central, state governments and union territories to immediately issue orders banning smoking in public places like hospitals, health institutes, public offices, public transport including railways, court buildings, educational institutions, libraries and auditoriums. Fundamental right guaranteed under Article 21 of the Constitution, Inter alia provides that non-smoker shall not be deprived of his life without due process of law. Right to food, starvation, death. State to provide free food. In a significant judgment in Preamble v. Union of India, the Supreme Court has held that the people who are starving because of their inability to purchase food grains have right to get food under Article 21, and therefore they ought to be provided the same free of cost by the states out of surplus stock lying with the states, particularly when it is unused and rotting. Q25. What is preventive detention? What constitutional safeguards are available to detenu against preventive detention laws? Ans. Article 22 of the Constitution provides preventive detention laws. The object of preventive detention is to prevent a person from committing a crime and not to punish him, as is done under punitive detention. Preventive detention has not been unknown in other democratic countries like England and Canada, but their recourse has been had to it only in wartime. The legislative capacity of Parliament or the state legislatures to enact a law of preventive detention is, however, limited to clauses 4 to 7 of Article 22, which lay down a few safeguards for a person subjected to such detention. The scheme of these clauses is to classify preventive detention in 3 categories, viz. A. A preventive detention up to 2 months, provision for which may be made either by Parliament or a state legislature. In such a case, no reference may be made to an advisory board. However, Constitution, 44th Amendment Act, 1978, has substituted a new clause for Clause 4, which now reduces the maximum period for which a person may be detained without obtaining the opinion of advisory board from 3 months to months. The detention of a person for a longer period than 2 months can only be made after obtaining the opinion of the advisory board. B. Preventive detention for over 3 months subject to safeguard of an advisory board consisting of persons qualified to act as High Court judges. No person can remain in preventive detention for more than 3 months unless the board holds that, in its opinion, there are sufficient cause for detention. The Supreme Court has held in Puranlal Lakhanlal v. Union of India, AIR 1958 SC 163 that the advisory board's function is not to determine the period of detention but only to determine whether the detention by itself is justified. C. Preventive detention for over 3 months without the safeguard of an advisory board. Such detention is possible if Parliament prescribes by law the circumstances under which, and the class or classes of cases in which a person may be detained for over 3 months without reference to advisory board. Parliament may also prescribe the maximum period for which a person can be detained in cases B and C. This provision, it has been held, is merely permissive and does not oblige Parliament to prescribe any maximum period. Further, Parliament may by law prescribe the procedure to be followed by an advisory board in an inquiry under Clause 4. The following safeguards have been provided to a detenu. 1. Grounds of detention must be communicated. Article 22, 5, gives the right to the detenu to be communicated the grounds of detention as soon as possible. The detaining authority making the order of detention must as soon as possible communicate to the person detained the grounds of his arrest and to give the detenu the earliest opportunity of making representation against the order of the detention. In Ram Bahadur v. State of Bihar, AIR 1975 SC 245, it has been held that where the order of detention is founded on distinct and separate grounds, if any of the grounds is vague or irrelevant, the entire order must fail. 2. Right of representation. Article 22 imposes an obligation upon the government to afford the detenu the opportunity to make representation under Clause 5. It makes no distinction between order of detention for only 2 months or less and those for a long duration. The obligation applies to both kinds of orders. It does not say that the representation will be considered by the appropriate government in the former class of cases and by the board in the latter class of cases. It is clear from clauses 4 and 5 of Article 22 that there is a dual obligation on the appropriate government and dual right in favor of a detenu, namely, 1. To have his representation irrespective of the length of detention considered by the appropriate government, and 2. To have once again in the light of the circumstances of the case considered by the board before it gives its opinion. 3. Advisory Board. Article 22 provides that the detenu under the Preventive Detention Law shall have the right to have his representation against his detention reviewed by an advisory board. If the advisory board reports that the detention is not justified, the detenu must be released forthwith. If the advisory board reports that the detention is justified, the government may fix the period for detention. The 44th Amendment Act 1978 has amended Article 22 and reduced the maximum period for which a person may be detained without obtaining the opinion of the advisory board from 3 months to 2 months. It has also changed the constitution of the board, which shall now consist of a chairman and 2 other members. The chairman must be a sitting judge of the appropriate high court, and the other members shall be either sitting or retired judges of any high court. The detenu has no right of legal assistance in the proceedings before the advisory board. But if the government is given such a facility, it should equally be provided to the detenu. The discretion of the board to permit or not to permit must be exercised in conformity with Articles 14 and 21 of the Constitution, i.e., it must not be exercised arbitrarily. Nand Lal v. State of Punjab, AIR 1981 SC 2041. In ADM Jabalpur v. SS Shukla, AIR 1976 SC 1207, the Supreme Court had held that when an emergency is declared and the right to enforce fundamental right under Article 21 is suspended, no person had right to go to court for challenging the validity of his detention. The effect of decision is that the court would not be empowered to examine the question of mala fide on grounds of the order of detention. In Makhan Singh v. State of Punjab, AIR 1964 SC 381, it had ruled that it could examine the validity of the detention on the ground that the order was passed with malice, or there was excessive delegation of power, or the provisions of emergency law were not followed. The court, however, held that Makhan Singh's case did not apply in this case. The 44th Amendment now provides that Article 21 will not be suspended during emergency and hence detention can be challenged in the court of law. Q. 26. How does the Indian Constitution guarantee the right against exploitation? Ans. Article 23 of the Constitution of India prohibits traffic in human being and begar and other similar forms of forced labor. The second part of this article declares that any contravention of this provision shall be an offence punishable in accordance with law. Clause 2, however, permits the state to impose compulsory services for public purposes, provided that in making so it shall not make any discrimination on grounds only of religion, race, caste, or class, or any of them. According to Article 24, no child below the age of 14 years shall be employed to work in any factory or mine or engaged in any other hazardous employment. Traffic in human beings means selling and buying men and women like goods, and includes immovable traffic in women and children for immoral or other purposes. Though slavery is not expressly mentioned in Article 23, it is included in the expression traffic in human being. Under Article 35 of the Constitution, Parliament is authorized to make laws for punishing acts prohibited by this article. In pursuance of this article, Parliament has passed the Suppression of Immoral Traffic in Women and Girls Act, 1956, for punishing acts which result in traffic in human beings. Article 23 protects the individual not only against the state but also private citizens. It imposes a positive obligation on the state to take steps to abolish evils of traffic in human beings and begar and other similar forms of forced labor wherever they are found. In People's Union for Democratic Rights v. Union of India, AIR 1980 to SC 1943, Supreme Court held that scope of Article 23 is wide and unlimited and strikes at traffic in human being and begar and other forms of forced labor wherever they are found. It is not merely begar which is prohibited by Article 23 but also all other forms of forced labor. Begar is a form of forced labor under which a person is compelled to work without receiving any remuneration. This article strikes at forced labor in whatever form it may manifest itself, because it is violative of human dignity and contrary to basic human values. The practice of forced labor is condemned in almost every international instrument dealing with human rights. Every form of forced labor, begar or other forms, is prohibited by Article 23, and it makes no difference whether the person who is forced to give his labor or service to another is paid remuneration or not. Even if remuneration is paid, labor or services supplied by a person would be hit by this article. If it is forced labor, e.g. labor supplied not willingly but as a result of force or compulsion. In Sanjit Roy v. State of Rajasthan, AIR 1983 SC 328, it has been held that the payment of wages lower than the minimum wages to the person employed on famine relief work is violative of Article 23. Whenever any labor or service is taken by the state from any person who is affected by drought and scarcity condition, the state cannot pay him less wage than the minimum wage on the ground that it is given them to help to meet famine situation. The state cannot take advantage of their helplessness. In Bandhu Mukti Morcha v. Union of India, AIR 1984 SC 802, the Supreme Court held that when an action is initiated in the court through public interest litigation alleging the existence of bonded labor, the government should welcome it, as it may give the government an opportunity to examine whether bonded labor system exists and as well as to take appropriate steps to eradicate that system. This is the constitutional obligation of the government under Article 23, which prohibits forced labor in any form. Q27 explain the scope of freedom of religion as guaranteed under Constitution of India. Or, in what manner is our Constitution secular? Examine the constitutional limits in which religious freedom is avoidable to an individual in India. Ans. Articles 25 to 28 of the Constitution of India deal with the fundamental rights relating to freedom or religion. Their rights are guaranteed to all persons and not merely to citizens. India is a secular state and therefore no preferred religion. All religions enjoy the same constitutional protection without any discrimination. Constitutional provisions. Article 25 provides that all persons are equally entitled to freedom of conscience and the right to freely profess, practice and propagate religion subject to public order, morality and health. Article 26 says that subject to public order, morality and health, every religious denomination or any section thereof shall have the right a. to establish and maintain institutions for religious and charitable purposes. b. to manage its own affairs in matters of religions. c. to own and acquire movable and immovable property, and d. to administer such property in accordance with law. Article 27 of the Constitution provides that state shall not compel any citizen to pay any taxes for promotion or maintenance of any particular religious institution. Article 28 lays down that no religion's instructions shall be given in any educational institution wholly maintained out of state fund. Meaning of religion. The word religion has wide connotation. Religion is a matter of faith with individuals. Religion lays down certain code of ethical rules for the observance by its followers. It is not confined to religious belief but extends to various rituals and ceremonies and modes of worship which the followers of a particular religion consider necessary and conducive for the members of their community. In S.R. Bommai v. Union of India, 1994, 3 SCC 1 Supreme Court has held that secularism is a basic feature of Constitution. State treats equally a religious and religious denominations. Religion is a matter of individual faith and cannot be mixed with secular activities. Secular activities can be regulated by state by enacting a law. Restrictions on the freedom of religion. The freedom of religion is subject to following restrictions. 1. Public order, morality, and health. Nothing can be done in the name of religion which will adversely affect public order, morality, and health. In Ghulam Abbas v. State of UP, 1984, 1 SCC 81 Supreme Court has held that shifting of a property, grave, connected with religion to avoid clashes between two religious communities or sects is valid and does not affect religious rights being in the interest of public in general. An order under Section 144 of Criminal Procedure Code prohibiting such a procession in the interest of public order and morality is not violative of Articles 25 and 26 of the Constitution. 2. Regulation of secular and financial activities. Article 25, 2a, provides that nothing shall affect the operation of any existing law or prevent the state from making any law, regulating or restricting any economic, financial, political or other secular activities which may be connected with religious practice. In Mohd Hanif Qureshi v. State of Bihar, AIR 1958 SC 731, it was held that slaughter of a cow on the day of Bakrid was not an essential element of Muslim religion and hence could be prohibited by law. 3. Social reforms. Article 25, 2b, provides that the state is empowered to pass a law providing for social welfare or social reforms or throwing open of religious institutions of a public character to all classes and sections of Hindus. Under Article 25, 2, state can eradicate social dogmas which stand in the way of country's progress. In State of Bombay v. Narsu Appamali, AIR 1952 Bong. 84, an act which prohibited bigamy was held to be valid under Article 25, 2b. Thus, where there is a conflict between the social need and religious practice, religion must yield. Hence, the freedom of religion is confined to only matters of religion and state can regulate secular and economic activities connected with religion. In Ismail Farooqi v. Union of India, 1994, 6 SCC 360 the Supreme Court, by a majority has held that the state can in exercise of its sovereign power acquire places of worship like mosques, churches, temples, etc., which is independent of Article 300- of the Constitution if it is necessary for maintenance of law and order. Such acquisition per se does not violate Articles 25 and 26 of the Constitution. What is protected under Articles 25 and 26 is a religious practice which forms an essential and integral part of religion. A practice may be a religious practice but not an essential part of religious practice. While offer of prayer or worship is a religious practice, its offering at every location where such prayers can be offered would not be an essential religious practice. Status of mosque in secular India is same as and not higher than that of places of worship of other religions such as temple, church, etc. A mosque is not an essential part of the practice of the religion of Islam, and namaz, prayer, by Muslims may be offered anywhere, even in open. The right to worship does not include the right of worship at every place, so long as it can be practiced effectively, unless the right to worship at a particular place is itself an integral part of that right. Q28 discuss the cultural and educational rights as guaranteed to linguistic and religious minorities under the Constitution of India. Ans. Cultural and educational rights of minorities. Article 29 and 30 of the Constitution of India guarantees certain cultural and educational rights to the citizens of India. According to Article 29, any section of the citizens residing in the territory of India, or any part thereof having a distinct language, script or culture of its own shall have the right to conserve the same. No citizen shall be denied admission into educational institution maintained by the state or receiving aid out of state funds on the grounds only religion, race, caste, language or any of them. According to Article 30, all minorities, whether based on religion or language, shall have the right to establish and administer educational institution of their choice. The 44th Amendment Act 1978 has inserted a new clause, 1-A, to Article 30 which provides that in making any law providing for the compulsory acquisition of any property of an educational institution established and administered by a minority referred to in Clause 1, the state shall ensure that the amount fixed by or determined under such law for the acquisition of such property is such as would not restrict or abrogate the right guaranteed under that clause. Clause 2 of Article 30 prohibits the state from making discrimination in the matter of grant of aid to any educational institution on the ground that it is managed by a religious minority or linguistic minority. The fundamental freedom to establish and administer educational institution by minorities guaranteed under Clause 1 of Article 30 is absolute in terms. It is not subject to any reasonable restrictions of the nature provided in Article 19 of the Constitution. All minorities, linguistic or religious, have under Article 30 an absolute right to establish and administer educational institutions of their own choice. Any law or executive direction which seeks to infringe the substance of that right under Article 30(1) would to that extent be void. The right to administer educational institutions of their choice is not, however, an absolute right. This is subject to regulation which are meant for ensuring the efficiency and smooth functioning of the minority institutions. The right to administer is not the right to maladministration. But the regulatory measures must be reasonable and should not be destructive of the minority character of the institution. In Re the Kerala Education Bill, AR 1958 SC 956, it was observed that a minority community can effectively conserve its language, script or culture by and through educational institutions, and therefore, the right to establish and maintain educational institutions of its choice is a necessary concomitant to the right to conserve its distinctive language, script or culture, and that is what is conferred on all minorities by Article 30(1). This right, however, is subject to Clause 2 of Article 29, which provides that no citizen shall be denied admission into any educational institutions maintained by the state or receiving aid out of state funds on the grounds only of religion, race, caste, language or any of them. In State of Bombay v. Bombay Education Society, AIR 1954 SC 561, it was observed, where a minority, like the Anglo-Indian community, which is based, inter alia, on religion and language, has the fundamental right to conserve its language, script and culture, to conserve its language, script and culture under Article 29, 1, and has the right to establish and administer educational institutions of their choice under Article 30, 1, surely then there must be implicit in such fundamental right the right to impart instruction in their own institutions to the children of their own community in their own language. To hold otherwise will be to deprive Article 29, 1, and Article 30, 1, of the greater parts of their contents. Such being the fundamental right, the police power of the state to determine the medium of instruction must yield to this fundamental right to the extent it is necessary to give effect to and cannot be permitted to run counter to it. In W. Proust v. State of Bihar, AIR 1969 SC 465, it was observed that the width of Article 30, 1, cannot be cut down by introducing in it considerations on which Article 29, 1, is based. The latter article is a general protection which is given to minorities to conserve their language, script or culture. The former is a special right to minorities to establish educational institution of their choice. This choice is not limited to institutions seeking to conserve language, script or culture, and the choice is not taken away if the minority community, having established an educational institution of its choice, also admits members of other communities. That is a circumstance irrelevant for the application of Article 30, 1, since no such limitation is expressed and none can be implied. The two articles create two separate rights, although it is possible that they may meet in a given case. In DAV College, Bhatinda v. State of Punjab, AIR 1971 SC 1731, the university declared that Punjabi would be the sole medium of instruction in the affiliated colleges. The court held that the right of the minority to establish and administer educational institutions of their choice includes the right to have a choice of medium of instructions also, and the university circular was directly infringing upon the rights of minorities to have instructions in Hindi as their own language and, therefore, was violative of Articles 29, 1, and 30, 1 of the Constitution. The right under Article 30, 1, is available to both the pre-Constitution and post-Constitution institutions. Recently, Supreme Court in TMA Pi Foundation v. State of Karnataka, AIR 2003 SC 355, the 11-judge constitutional bench led by Chief Justice B.N. Kirpal by 6-5 majority has held that minority educational institution not aided by the state cannot be regulated by the state. However, if an institution was aided by the state, it can be regulated by the state. The minority community has a right to establish educational institution. The state and universities can, however, provide educational qualifications for the teaching staff. The court held that the state and the university concerned will not interfere in the management of unaided minority schools so long as the education is transparent and merit is given primacy in admissions, more so in professional institutions. On the question as to who constitutes a minority, the court said the linguistic and religious minorities have to be considered on the basis of states and the population therein, as the states were reorganized on the basis of language. Explaining the extent of state control, the court said admission of students to unaided minority educational institutions where the scope for merit-based selection was practically nil could not be regulated by the state government or university, except for providing the qualifications and minimum conditions of eligibility in the interest of academic standards. However, it said this right is subject to the condition that admission to the unaided educational institution was on a transparent basis and merit was adequately taken care of. As regards to aided institutions, the court made it clear that a minority institution does not cease to be so the moment grant in aid is received. An aided minority educational institution will be entitled to have the right of admission of students belonging to the minority group. At the same time, it would be required to admit a reasonable extent of non-minority students so that the rights under Article 30(1) are not substantially impaired and further, citizens' rights under Article 29(2) are not infringed. The court empowered the state governments to notify the percentage of non-minority students to be admitted. It would vary according to the types of institutions. The courses of education and other factors such as educational needs, observance of inter se merit amongst the minority groups could also be ensured. Q29. What are the provisions of the Constitution which are meant for protecting the laws giving effect to the directive principles from being challenged as violative of the fundamental rights? Ans. The Constitution, 25th Amendment, Act, 1971 added a new Article 31C to the Constitution. This article was inserted in the Constitution in order to give protection to laws enacted for giving effect to the directive principles contained in Article 39(b) and (c) of the Constitution. Article 31C provides that no law which is passed to give effect to the directive principles contained in Article 39(b) and (c) shall be deemed to be void on the ground that it is inconsistent with or takes away or abridges any of the rights conferred by Articles 14 or 19. Article 31C was again amended by the Constitution, 42nd Amendment, Act 1978, which widened its scope so as to cover all directive principles. Thus, the amendment provided that a law enacted for giving effect to all or any of the directive principles laid down in Part V could not be challenged as violative on the ground that it was inconsistent with or takes away or abridges any of the rights conferred by Article 14 or 19 of the Constitution. It also provides that the law containing a declaration that it is for giving effect to such policy cannot be called in question in any court on the ground that it does not give effect to such policy. In Keswananda Bharati v. State of Kerala, AIR 1973 SC 1461, the Supreme Court upheld the validity of the new Article 31C of the Constitution. However, it declared the second part of Article 31C as unconstitutional. In Minerva Mills Limited v. Union of India, AIR 1980 SC 1789, the Supreme Court struck down Article 31C as amended by the Constitution 42nd Amendment Act, 1978 on the ground that it destroys the basic structure of the Constitution as it disturbs the basic harmony between fundamental rights and the directive principles. In Vaman Rao v. Union of India, AIR 1980 SC 73, the Supreme Court held that Article 31C as it stood before the 42nd Amendment is valid as it gives effect to specific objectives as laid down in Article 39(b) and (c) of the Constitution. Thus, after this judgment, the position is that there is no conflict between the fundamental rights and the directive principles. Q30. Compare the writ jurisdiction of the Supreme Court with that of High Courts under the Indian Constitution. Ans. Article 32 of the Constitution of India provides one of the most important constitutional remedies. It gives right to move the Supreme Court by appropriate proceedings for the enforcement of the rights conferred by Part 3 of the Constitution. For the enforcement of the fundamental rights, a parallel writ jurisdiction has been conferred on the High Courts under Article 226. As regards the interrelation between the two articles, it appears that Supreme Court's jurisdiction is independent of and is in no way curtailed or qualified by the jurisdiction of High Court. A person aggrieved of violation of his fundamental rights may come straight to Supreme Court for relief, and he is not bound to invoke the jurisdiction of the High Court first. The reason is Article 32 is itself a fundamental right and provides for remedy in case of violation of fundamental right. In Gopal Das v. Union of India, AIR 1955 SC1, Supreme Court observed that the sole object of Article 32 is the enforcement of the fundamental rights guaranteed by the Constitution. Whatever other remedies may be open to a person aggrieved, he has no right to complain under Article 32, where no fundamental right has been infringed. In Kochuni v. State of Madras, AIR 1959 SC 727, the court held the view that Article 32 is the most powerful weapon in the hand of the Supreme Court of India. With this power, it keeps the legislature and executive within bounds of their respective powers. In Fertilizer Corporation Kamgar Union v. Union of India, AIR 1981 SC 345, it has been held that the jurisdiction conferred on the Supreme Court by Article 32 is an important part of the basic structure of the Constitution because it is meaningless to confer fundamental rights without providing an effective remedy for their enforcement. When they are violated, Parliament may empower the Supreme Court with such a power under Article 139. But the power of the High Court to issue writs cannot be in derogation of the Supreme Court under Article 226. In other words, an order under Article 32 will supersede the orders of the High Court previously passed. The power of the Supreme Court to issue writs under Article 32 is a bit narrower than that of the High Courts under Article 226 of the Constitution. Under Article 32, a writ can be issued only for the infringement of fundamental rights guaranteed under Part 3. But under Article 226, writs can be issued for the infringement of the fundamental rights or for any other purpose. Thus, the High Courts enjoy a wider power under Article 226 to issue writs, orders, or directions. Following are the cases in which application of Article 32 does not lie. 1. In Sadhu Singh v. Delhi Administration, AIR 1965 SC 9, it has been held that the court will not under Article 32 interfere with an administrative order, however erroneous, where the constitutionality of the statute or the order made thereunder is not challenged on the ground of contravention of a fundamental right. 2. Article 32 of the Constitution is not directly concerned with the determination of the constitutional validity of a particular legislative enactment. To make out a case under this article, it is incumbent upon the petitioner to establish not merely that the law complained of is beyond the competence of the particular legislature as not being covered by any of the items in the legislature list, but that it affects or invades his fundamental rights guaranteed by the Constitution, of which he could seek enforcement by an appropriate writ or order. Chiranjit Lal v. Union of India, 1950 SC 109. Clause 1 of Article 32 guarantees the right to move the Supreme Court for seeking relief from the court by way of 5 writs as contained in the clause. The Supreme Court of India may not only issue above writs but also directions, orders, or writ similar to the above so far as to fit in with any circumstances peculiar to India. But the remedy must be sought within reasonable time. In Somavanti v. State of Punjab, AIR 1964 SC 131, Supreme Court has held that where the suspension of fundamental rights has the constitutional protection, Article 32 will have no operation. Q. 31. What do you understand by writs? Explain the circumstances in which various writs can be issued. Or write a short note on I. Habeas corpus, 2. Mandamus, 3. Quo warranto, 4. Certiorari, and v. Prohibition. Uns. Meaning writs. According to Lord Halsbury, writ can be called those extraordinary remedies which are issued upon cause shown in cases where the ordinary legal remedies are inapplicable or inadequate. There are two kinds of writs: the prerogative writs and the original or judicial writs. The original or judicial writs commence between party and party and they issue as of course. The prerogative writs are exceptional processes which issue only upon proper cause shown. As the prefix prerogative suggests, they do not originate from the enacted or common law but issue from the sovereign rights of the king as the fountainhead of justice. The prerogative writs are ancient remedial processes of an extraordinary nature, which have from the earliest time issued from the Court of King's Bench, in which the sovereign was always present in compensation of law. The jurisdiction to issue such writs was later on extended to the High Court of Justice under the Supreme Court of Judicature Act, 1925 in England. What writs can be issued? Under Articles 32 and 226, the Constitution of India confers upon the Supreme Court and the High Courts respectively the power to issue direction, orders, or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto and certiorari for the enforcement of the fundamental rights, and in the case of High Court, for any other purpose also. In the case of Fertilizer Corporation Kamgar Union v. Fertilizer Corporation, AIR 1981 SC 344, the importance of Article 32 has been explained in following words. The jurisdiction conferred on Supreme Court has been characterized as an important and integral part of the basic structure of the Constitution, as it is meaningless to confer fundamental rights without providing any effective machinery and remedy for their enforcement, if and when they are violated. I. Habeas corpus. This right lies when a person has been detained unlawfully. It may be used to secure release of a person from confinement without legal justification. In India, detention may be unlawful if, inter alia, it is not in accordance with law, or there is no valid law to warrant it, or the law is invalid because it infringes a fundamental right, or the legislature enacting it exceeds its limit. The great value of this writ is that it enables the immediate determination of the right of a person's freedom. In Kanu Sanyal v. District Magistrate, Darjeeling, AIR 1983 SC 653, the Supreme Court has held that while dealing with the application of writ of habeas corpus, production of the body of the person allegedly to be unlawfully detained was not essential. Justice Bhagwati held in this case that in a writ of habeas corpus under Article 32, the production of the body of the person detained is not necessary for hearing and disposing of the writ petition by the court. The production of body of the person detained illegally is not the essential feature of the writ of habeas corpus. Who can apply for the writ? The general rule is that an application can be made by a person who is illegally detained. But in certain cases, an application for habeas corpus can be made by any person on behalf of the petitioner, i.e. his friend or a relation. The writ of habeas corpus can not only be used for releasing a person illegally detained, but it will also be used for protecting him from inhuman treatment inside the jail. This writ is issued to the authority who has the aggrieved party in his custody. When on a petition for the writ the court considers that a prima facie case for granting the prayer has been made out, a rule nisi is called upon the custodian of the prisoner to show cause why the writ cannot be issued. If the cause is shown insufficient, the writ is issued for setting the prisoner free. The writ is not issued if the custodian can satisfy the court that the prisoner is not under unlawful detention. The Supreme Court has held in Janardhan v. State of Hyderabad, AIR 1951 SC-17 that if it should appear on the face of return that a person is in detention in execution of a sentence or an indictment on a criminal charge, that would be a sufficient answer to an application for a writ of habeas corpus. 2. Writ of mandamus. Mandamus is a judicial remedy which is in the form of an order from a superior court to any government, court, corporation, or public authority to do or to forbear from doing some specific act which that body is obliged under law to do or refrain from doing, as the case may be, and which is in the nature of a public duty and in certain cases of a statutory duty. No one can ask for a mandamus without a legal right. There must be a judicially enforceable as well as legally protected right before one suffering a legal grievance can ask for a mandamus. A person can be said to be aggrieved only when he is denied a legal right by someone who has a legal duty to do something and obtains from doing it. In the words of the Supreme Court, there must be in the applicant a right to compel the performance of some duty caused on the opponent. The duty sought to be enforced must have three qualities. It must be a duty of a public nature. A duty will be of a public nature if it is created by the provisions of the Constitution or of a statute or some rule of common law. A duty corresponding to a private. 3. Quo warranto. By issuing the writ of quo warranto, the court seeks from the person to whom it is issued information as to the warrant or authority by which the said person supports his right to an office, franchise or liberty. It lies against a person who claims or usurps an office, franchise or liberty with respect to which information is sought so that such person's right to the same may be determined in the light of the authority or warranto cited by such person in support thereof. The writ of quo warranto cannot be issued unless the defendant is in actual possession of the office and exercises the office v. Green, 2 QB. 460. The holding of a liberty as a matter of fact is a condition precedent to the determination of a right to the same and the calling up of information with regard to it. A motion for a writ of quo warranto can be made at the instance of a private person although he is not personally aggrieved or interested in the matter. The motion does not require the intervention of the government or any public authority. This type of writ is a discretionary remedy and is not issued as a matter. In G.D. Karkare v. T.L. Shevde, AIR 1950 to NAD. 330, the appointment of the Advocate General of Madhya Pradesh was questioned by quo warranto. An objection was taken that mere a private individual seeking neither enforcement of his fundamental right nor any other legal right cannot ask for quo warranto. The High Court held that there was no reason to refuse a citizen under a democratic republican constitution to move for a writ of quo warranto for testing the validity of high appointment under the Constitution. On merit, however, it was held that there was no defect in the appointment questioned in the writ. The writ of quo warranto can go only to public offices and not to private bodies like the managing committee of a school, as has been held in Amrendra v. Narendra, AIR 1953 calories. 114. 4. Certiorari. It is a command or order by the superior court to an inferior court or tribunal to transmit a record or cause or matter pending before them to the superior court not to proceed with the case which is not within its jurisdiction, and also to quash any order made by the court in such a case. If the order of inferior court is found to be without jurisdiction or against the principles of natural justice, it will be quashed. In Champalal v. The Commissioner of Income Tax, AR 1970 SC 645, it was held that a petition for a writ of certiorari may lie to High Court where the order is on the face of it erroneous or raise question of jurisdiction of infringement of fundamental right of the petitioner. Who may apply? Any person whose legal right has been violated can apply for the issue of this writ. Any person may on behalf of a group of persons or society or persons at large. Grounds on which the writ is issued. The following conditions must be fulfilled before a writ of certiorari can be issued. 1. The act, order or judgment, in respect of which the writ is sought to be issued should be the act, order or judgment of an inferior court or statutory body exercising judicial or quasi-judicial functions. 2. Such court or body must have acted in absence or in excess of the jurisdiction vested in it the principles of natural justice so as to render such act, order or judgment invalid. 3. Where there is violation of the principles of natural justice so as to render such act, order or judgment invalid. 4. When there is an error apparent on the face of record. In the case of Gujarat Steel Tubes v. Its Mazdoor Sabha, AIR 1980 SC 1896, Supreme Court explained the meaning of the phrase error apparent on the face of record. It was held that every order cannot be corrected merely because it is wrong. It can be quashed only if it is vitiated by the fundamental flaw of gross miscarriage of justice, absence of legal evidence, perverse misreading of facts, serious errors of law on the face of order, jurisdictional failure and the like. In Harbanslal v. Jagmohan Saran, AIR 1986, 302, it has been held that the writ of certiorari is issued only if the order of the inferior tribunal or subordinate court suffers from the error of jurisdiction or from breach of principles of natural justice or if vitiated by an apparent error of law. The grounds mentioned above for quashing the orders are self-explanatory of the term error on the face of record. Prohibition. A writ of prohibition commands the court or tribunal to whom it is issued to refrain from doing something which it is about to do. So writ of prohibition is issued by a court of superior jurisdiction directing an inferior court for the purpose of preventing the inferior court from usurping a jurisdiction with which it is not legally vested or to compel courts entrusted with judicial duties to keep within the limits of their jurisdiction. Thus the writ lies both for excess of jurisdiction and absence of jurisdiction. Prohibition has much in common with certiorari. Thus both these writs lie against a judicial or quasi-judicial body but not against an executive body. But there is one fundamental distinction between the two writs. They are issued at different stages of the proceedings. When an inferior court takes up for hearing a matter over which it has no jurisdiction, the person against whom the proceedings are taken can move the superior court for a writ of prohibition, and on that, an order will issue forbidding the inferior court from continuing the proceedings. On the other hand, if the court hears that case or matter and gives a decision, the party aggrieved will have to move the superior court for a writ of certiorari, and on that, an order will be made quashing the decision on the ground of want of jurisdiction. Sometimes the two writs may overlap. Thus it may happen that in a proceeding before the inferior court a decision might have been passed which does not completely dispose of the matter, in which case it might be necessary to apply both for certiorari and prohibition, certiorari for quashing what has had been decided, and prohibition for arresting the further continuance of the proceeding. Broadly speaking, a writ of prohibition will lie when the proceedings are to any extent pending, and writ of certiorari for quashing other they have terminated in a final decision. It is well settled that where proceedings of an inferior court or tribunal are party within and party without jurisdiction, the prohibition will lie against doing what is in excess of jurisdiction. In Bengal Immunity Company Limited v. State of Bihar, AIR 1955 SC 661, Supreme Court observed that the existence of an alternative remedy may be more relevant in the context of a writ of a certiorari, but where an inferior tribunal is shown to have usurped jurisdiction which does not belong to it, that consideration is irrelevant and the writ of prohibition has to be issued as of right. Q30 to discuss the nature, scope and purpose of directive principles of state policy as enumerated in Constitution. Or enumerate the directive principles of state policy. Ans. Articles 38 to 51 of the Constitution provide certain directive principles or policies to be pursued by the governments in the governance of the country. These principles are embodied as directions to the legislative and executive branches of the government to follow them in their routine working. These directive principles impose certain obligations on the state to take positive action in certain directions in order to promote the welfare of the people and to achieve economic democracy. Directive principles are more akin to moral rather than to legal precepts, as they are non-justiciable. Directive principles have been included in the Constitution for following reasons. 1. Constitutional declarations regarding social and economic policies have become increasingly frequent. 2. Directive principles have at least educative value. 3. These principles serve as restraint on those who might capture power. The directive principles require the state to take positive action, and since they can be guaranteed only so far as such action is practicable in the circumstances, the state is bound under its constitutional obligation to apply these principles in making laws. In Kerala Education Bill, AR 1958 SC 956, the Supreme Court has stated that in determining the scope and ambit of the fundamental rights relied on by or on behalf of any person or body, the court may not entirely ignore the directive principles but should adopt the principle of harmonious construction and should attempt to give effect to both as far as possible. The directive principles are a ready and dependable index of what a public purpose is intended to be. The object of directive principles. According to Dr. Ambedkar, the directive principles are instruments of instructions to the legislature and the executives. Explaining the significance of these principles in the Constitution, Dr. Ambedkar said, "Whoever captures the power will not be free to do what he likes with it. In the exercise of it, he will have to respect these instruments, which are called directive principles. He cannot ignore them. These principles have the same place as the conventions in the English Constitution, which have come to acquire sanctity not inferior to the sanctity of law, or rather superior to it, inasmuch as the strictly legal aspect of things under the English Constitution yields places to the conventions deemed essential to democracy. These are not justiciable. They are merely guidelines to government in action." The directive principle of state policy are as follows. Directive principles generally. I. The state shall strive to promote the welfare of the people by securing a social order permitted by social, economic and political justice. Article 38, 1. 2. The state shall, in particular, strive to minimize the inequalities in income and endeavor to eliminate inequalities in status, facilities, and opportunities not only amongst individuals but also amongst groups of people residing in different areas or engaged in different vocations. Article 38, 2. 3. The state shall endeavor to secure just and human conditions of work, a living wage, a decent standard of living and social and cultural opportunities for all workers. Article 43. 4. The state shall endeavor to raise the level of nutrition and standard of living and to improve the health of the people. Article 47. We. Promotion of international peace and amity. Article 51. 6. Equitable distribution of the material resources of the community and prevention of concentration of wealth and means of production. Article 39. The Constitution, 42nd Amendment, Act, 1976, has amended Article 39, F. The new clause provides that children are given opportunities and facilities to develop in a healthy manner and in condition of freedom and dignity, and that childhood and youth are protected against exploitation and against moral and material abandonment. While interpreting the word distribution used in Article 39, B. Justice Krishna Iyer said in the state of Karnataka v. Ranganath Reddy, AIR 1978 SC 215, that it cannot be given full play as it fulfilled the basic purpose of restructuring the economic order. It embraces the entire material resources of the community. Its task is to distribute such resources. Its goal is to undertake distribution as best subserve the common good. It recognizes by such distribution the ownership and control. Directive in shaping the policy of the state. 1. To establish economic democracy and justice by securing certain economic rights. 2. To secure a uniform civil code for the citizens. Article 44. 3. To provide free and compulsory primary education. Article 45. 4. To prohibit the consumption of liquor and intoxicating drugs except for medical purpose. Article 47. 5. To develop cottage industries. Article 43. 6. To organize agriculture and animal husbandry on modern lines. Article 48. 7. To prevent slaughter of useful cattle, i.e., cows, calves, and other milch and draught cattle. Article 48. 8. To organize village panchayats as units of self-government. Article 40. 9. To protect and maintain places of historic, artistic interest. Article 49. 10. To separate the judiciary from the executive. Article 50. 11. To promote with special care the educational and economic interest of the weaker sections of the people. Article 46. Directive in the nature of non-justiciable rights of every citizen. I. Right to adequate means of livelihood. Article 39, A. 2. Right of both sexes to equal pay for equal work. Article 39, D. 3. Right against economic exploitation. Article 39, E. F. 4. Right to work. Article 41. We. Right to education. Article 41. 6. Right to public assistance in case of unemployment, old age, sickness and other cases of undeserved want. Article 42. 7. Free legal aid to safeguarding backward class. Article 39-A. 8. Participation of workers in management of industries. Article 43-A. 9. Protection and improvement of environment and safeguarding of forests and wildlife. Article 48-A. 93rd Amendment Bill, 2001. The 93rd Amendment, Bill 2001, which will subsequently become the Constitution, 86th Amendment, Act 2001, proposes to substitute as new article for Article 45, which provides that the state shall endeavor to provide early childhood care and education for all children until they complete the age of 6 years. Q. 33. Examine the correlation between fundamental rights and directive principles of state policy. Ans. Relation between directive principles and fundamental rights. The directive principles differ from fundamental rights in this respect that while fundamental rights are justifiable and directive principles are non-justifiable. Under Article 37, the directive principles, though they are fundamental in governance of the country, and it shall be the duty of the state to apply these principles in making laws, but they are expressly declared non-justiciable. On the other hand, fundamental rights are enforceable by the courts, and the courts are bound to declare as void any law that is inconsistent with any of the fundamental rights. The directive principles are not so enforceable by the courts, nor can the courts declare as void any law which is otherwise void on the ground that it contravenes any provisions of the directive principles. It is now definitely settled that a directive principle cannot override a fundamental right. In case of a conflict between a fundamental right and a directive principle, it is the former nor the latter which prevails. This point was first settled by the Supreme Court in Madras v. Champakam Dorairajan, AIR 1951 SC-28, where the communal GO made by Madras government came in conflict with Article 29(2) of the fundamental right and therefore could not be supported under Article 46, in pursuance to which the GO was said to have been made. The main reason for this approach is that the fundamental rights are enforceable whereas directive principles are unenforceable. The Supreme Court observed as follows: the directive principles of the state policy, which by Article 37 are expressly made unenforceable by courts, cannot override the provisions found in Part 3 which, notwithstanding other provisions, are expressly made enforceable by appropriate writs, orders or directions under Article 32. The chapter on fundamental rights is sacrosanct and not liable to be abridged by legislative or executive act or orders, except to the extent provided in the appropriate article in Part 3. The directive principles of state policy have to conform and to run as subsidiary to the chapter on fundamental rights. In our opinion, that is the correct approach in which the provision found in Part 3 and 4 have to be understood. However, so long as there is no infringement of any fundamental right to the extent conferred by the provisions in Part 3, there can be no objection the state acting in accordance with the directive principles set out in Part 4, but subject again to the legislative and executive powers and limitations conferred on the state under different provisions. In Kerala Education Bill, AIR 1957 SC 956, the Supreme Court observed that though the directive principles cannot override the fundamental rights, nevertheless, in determining the scope and ambit of fundamental rights, the court may not entirely ignore the directive principles but should adopt the principles of harmonious construction and should attempt to give effect to both as much as possible. In Unni Krishnan v. State of AP, 1993, 1 SCC 645, Supreme Court has reiterated the same principle that the fundamental rights and directive principles are supplementary and complementary to each other, and provisions of Part 3 shall be interpreted having regard to the preamble and directive principles of state policy. Q. 34. What are the fundamental duties enumerated under Article 51 of the Constitution? What is the importance of these duties? Ans. For the first time, the Constitution, 42nd Amendment, Act 1976, enumerates and specifies the fundamental duties of citizens in the Constitution. It is significant to note that in none of the constitutions of Western countries the duties and obligations are specifically defined. The constitutions of socialist countries lay great emphasis on the duties of citizens. The fundamental duties are intended to serve as a constant specifically conferred on him certain fundamental rights equally. The citizen also is required to observe certain basic norms of democratic conduct and democratic behavior. While Constitution confers certain fundamental rights on the citizens, it also gives power to state to impose reasonable restrictions on these rights. The rights guaranteed by the Constitution are available to the citizens only when they fulfill their duties. This is implicit in the provisions of our Constitution. The newly added Article 51- runs as follows. 51A Fundamental Duties. It shall be the duty of every citizen of India A. To abide by the Constitution and respect its ideals and institutions, the national anthem. B. To cherish and follow the noble ideals which inspired our national struggle for freedom. C. To uphold and protect the sovereignty, unity and integrity of India. D. To defend the country and render national service when called upon to do so. E. To promote harmony and spirit of common brotherhood amongst all the people of India, transcending religious, linguistic and regional or sectional diversities, to renounce practices derogatory to the dignity of women. F. To value and preserve the rich heritage of our composite culture. G. To protect and improve the natural environment including forests, lakes, rivers and wildlife, and to have compassion for living creatures. H. To develop the scientific temper, humanism and the spirit of enquiry and reform. I. To safeguard public property and to abjure violence. J. To strive towards excellence in all spheres of individual and collective, so that the nation constantly rises to higher levels of endeavor and achievements. The Constitution, 93rd Amendment, Bill 2001 passed by Parliament proposes to add new clause, K, to Article 51-A which provides who is parent or guardian to provide opportunities for education to his child or as the case be, ward between the age of 6 to 14 years. In AIMS Students' Union v. AIMS, AIR 2001 SC 30 to 62, almost a quarter century after the people of India have given the Constitution unto themselves, a chapter on fundamental duties came to be incorporated in the Constitution. Fundamental duties, as defined in Article 51, are not made enforceable by a writ of court just as the fundamental rights are, but it cannot be lost sight of that duties in Part 4A. Article 51 are prefixed by the same word, fundamental, which was prefixed by the founding fathers of the Constitution to rights in Part 3. Every citizen of India is fundamentally duty-bound to strive towards excellence in all spheres of individual and collective activity so that the nation constantly rises to high levels of endeavor and achievements. Status, all the citizens placed together, and hence though Article 51 does not expressly cast any fundamental duty on the state, the fact remains that the duty of every citizen of India is the collective duty of every citizen of India is the collective duty of the state. Any reservation, apart from being sustainable on the constitutional anvil, must als. Q. 35 discuss the position of the President under the Indian Constitution. Ans. Position of President. Article 52 of the Constitution lays down that there shall be a President of India. Article 53, 1. provides that the executive powers of the Union shall vest in the President. Article 74, 1, lays down that there shall be a Council of Ministers with the Prime Minister at the head to aid and advise the President. Article 74, 2, provides that the question whether any advice was given by the Council of Ministers shall not be questioned in any court of law. Article 75 provides that the Prime Minister shall be appointed by the President and the other ministers shall be appointed by the President on the advice of the Prime Minister. The ministers shall hold office during the pleasure of the President. A purely literal interpretation of these provisions conveys the impression that the President, if so desires, can become a dictator. But this interpretation is not in tune with the spirit of the Constitution. In a parliamentary form of government, the President is a titular head and the real powers are vested with the Council of Ministers. In various cases like Ram Javaya v. State of Punjab, AIR 1955 SC 544, UN Rao v. Indira Gandhi, AIR 1974 SC 2192 and MS Vishambhar Dayal Chandra Mohan v. State of UP, AIR 1982 SC 33, the Supreme Court has held that the President is merely a ceremonial head and the real power lies with the Council of Ministers. The Constitution, 42nd Amendment Act, 1976, has now removed all doubts about the position of President to a greater extent. It has amended Article 74, which makes it obligatory for the President to act in accordance with the advice given by the Council of Ministers. But the Constitution, 44th Amendment Act, 1978, has inserted a proviso to Clause 1 of Article 74, according to which the President may require the Council of Ministers to reconsider such advice either generally or otherwise, and the President shall act in accordance with such reconsidered advice. This provision recognizes the essential rule of the President that he can advise and guide the government. Under our parliamentary system of government, the President is the constitutional head of the state while the real power vests in the Council of Ministers. In view of the following provisions, the position of the President is clear. 1. Article 75, 3, provides that the Council of Ministers is collectively responsible to the House of People for the executive functions. How can the Council of Ministers be made responsible for an act which is not performed by it but by the President? 2. Article 78a provides that it shall be the duty of the Prime Minister to communicate the President on any matter on which a decision has been taken by a minister. 3. The President is bound by the advice of the Council of Ministers even after the dissolution of the House of the People. Even after the dissolution of the House, the Council of Ministers remain in office and advise the President in exercise of his powers. Any exercise of powers by the President under such circumstances will be unconstitutional in view of Article 74, 1 of the Constitution. UN Rao v. Indira Gandhi, AIR 1971 SC 1002. Q. 36. How is the President of India elected? How can he be impeached? What qualifications are necessary for election of the President? What are the terms and conditions of his office? Ans. Election of President of India. According to Article 54 of Constitution of India, President shall be elected by the members of an electoral college constituting of A. The elected members of both Houses of Parliament, B. The elected members of the legislative assemblies of the states. Article 55 says that so far as practicable there shall be uniformity in the scale of representation of the different states at the election of the President. For the purpose of securing such uniformity among states inter se, as well as parity between the states as a whole and the Union, the number of votes which each elected member of Parliament and of the Legislative Assembly of each state is entitled to cost at such election shall be determined in following manner. A. Every elected member of Legislative Assembly of a state shall have as many votes as there are multiplies of 1,000 in quotient obtained by dividing the population of the state by the total number of the elected member of the Assembly. B. If after taking the said multiplies of 1,000s the remainder is not less than 500, then the vote of each member referred to in subclause A shall be further increased by 1. C. Each elected member of either House of Parliament shall have such number of votes as may be obtained by dividing the total number of votes assigned to the members of legislative assemblies of the state under subclauses A and B by the total number of the elected members of both Houses of Parliament, fractions exceeding one half being counted as one and other fractions disregarded. The election of the President shall be held in accordance with the system of proportional by means of the single transferable vote, and the voting at such election shall be by secret ballot. The Constitution, 42nd Amendment, Act, 1976 substitutes the old explanation given in Article 55. According to the substituted explanation, the expression population used in Article 55 means the population as ascertained at the last census of which the relevant figures have been published. The reference in the explanation to the last preceding census of which the relevant figures have been published shall, until the relevant figures for the first census taken after the year 2000 have been published, be construed as a reference to the 1971 census. This change has been brought under the new population policy. Accordingly, it makes consequential change in the relevant articles, namely 81 and 82 relating to Lok Sabha, Article 170 relating to state assemblies, Article 330 and 332 relating to reservation of seats for scheduled castes and scheduled tribes. The number of votes which any voter is eligible to vote for presidential election may be mathematically represented as follows. 1. The number of votes a member of any legislative assembly is eligible to cast be determined in accordance with the following formula. Population of state, 1000. Divided by total number of elected members of state assembly. If the remainder after dividing by 1000 is 5000 or more, than the vote of each member shall be further increased by 1. 2. The number of votes of a member of parliament shall be determined in accordance with the following method. Total votes assigned to members of all state assemblies divided by total number of elected members of both houses of parliament. If the fraction exceeds one half, then the vote of each MPs will further be increased by 1 vote. The President and Vice President Election Act, 1974 provides that the name of the president candidate must be proposed by at least 10 electors and be seconded by 10 electors, and also provides for the security deposit of 2,500 rupees. In Charan Lal Sahu v. Shri Neelam Sanjeeva Reddy, AIR 1978 SC 499, the Supreme Court observed that Article 58 only provides the qualifications or conditions for the eligibility of a candidate for president election. It has nothing to do with the nomination of a candidate, which requires 10 seconders. In President election case, AIR 1974 SC 1682, the holding of the election of the President was challenged on the ground that the Electoral College, as mentioned in Articles 54 and 55, would be incomplete because the Gujarat State Legislative Assembly was dissolved. The Supreme Court held that the election to the office of the President must be held before the expiration of the term of the President, notwithstanding the fact that at the time of such election the Legislative Assembly of Gujarat is dissolved. 1. Qualifications. Article 58 lays down the qualifications which a person must possess for being elected to the office of the President of India. A. He must be a citizen of India. B. He must have completed the age of 35 years. C. He must be qualified for election as a member of the House of the People, i.e. he must be registered as a voter in any parliamentary constituency. D. He must not hold any office of profit under the Government of India, or the government of any state or under any local or other authority subject to the control of any of the said governments. But the following persons shall not be deemed to hold any office or profit and hence qualified for being a candidate for presidentship. They are A. The President and Vice President of the Union, B. The government of any state, C. The Minister of the Union or of any state. Article 58. 2. Condition of President's office. Article 59 says that the President cannot be a member of either House of Parliament or of a House of the Legislature of any state. If a member of either House of Parliament or of a state legislature is elected President, he shall be deemed to have vacated his seat in that House on the date on which he enters upon his office as President. The President shall not hold any other office of profit. Q. 37 describe the procedure for impeachment of President. Ans. Procedure for impeachment of the President. Article 61 of the Indian Constitution lays down the procedure for the impeachment of the President. The provision of Article 61 are as follows. According to Article 61, 1. When a President is to be impeached for violation of the Constitution, the charge shall be preferred by either House of Parliament. No such charge shall be preferred unless A. The proposal to prefer such charge is contained in a resolution which has been moved after at least 14 days' notice in writing signed by not less than 1/4 of the total number of the members of the House has given their intention to move the resolution. Article 61, 2 and B. Such resolution has been passed by a majority of not less than 2/3 of the total membership of the House. Article 61, 3. According to Article 61, 4, when a charge has been so preferred by either House of the Parliament, the other House shall investigate the charge of cause to be investigated, and the Parliament shall have the right to appear and to be represented to such investigation. If as a result of the investigation a resolution is passed by a majority of not less than 2/3 of the total membership of cause to be investigated declaring that the charge preferred against the President has been sustained, such resolution shall have the effect of removing the President from the office as from the date on which the resolution is so passed. Q. 38 discuss the power of President under Constitution of India. Ans. The powers of the President under the Indian Constitution are as given below. 1. Executive powers. Article 52 of the Constitution lays down that there shall be a President of India. Further, Article 53, 1, provides that the executive powers of the Union shall be vested in the President and it shall be exercised by him either directly or through officers subordinate to him in accordance with law. The officers subordinate to him include ministers also. Emperor V. Srinath, AIR 1945 PC 163. 2. Power of appointment. The President shall appoint the Prime Minister, and other ministers shall be appointed by the President on the advice of the Prime Minister. Article 75, 1. The President appoints I. The Attorney General for India. Article 76. 2. The judges of the Supreme Court, Article 124. 3. The judges of the High Courts, Article 217. 4. Controller and Auditor General of India, Article 148. We, Governors of States, Article 155. 6. Finance Commission, Article 280. 7. Members and Chairmen of Union Public Service Commission, Article 316. 8. Joint Public Service Commission for a group of states, Article 316. 9. Commission to investigate on the condition of backward classes, Article 340. Kismaili Commission to report on the administration of scheduled areas, Article 339. 11. Special Officers for Scheduled Castes and Scheduled Tribes, Article 338. 12. Commission and Committee of Parliament on Official Language, Article 341. 3. Military powers. The President shall be Supreme Commander of the Defence Forces, and the exercise thereof shall be regulated by law, and Parliament shall have power to regulate or control the exercise of military powers by the President. 4. Power to grant pardons according to Article 72. 1. The President shall have the power to grant pardons, reprieves, respites or remissions of punishment, or to suspend, remit and commute the sentence of any person convicted by any offence. A. In all cases where the punishment or sentence is by a court-martial. B. In all cases where the punishment or sentence is for an offence against any law relating to a matter to which the executive powers of the Union extends. C. In all cases where the sentence is a sentence of death. 5. Emergency powers, Part 18. I. Articles 350 to 360 of the Constitution deals with the emergency powers of the President. The emergencies envisaged under the Constitution are of three kinds. 1. Emergency arising out of war, external aggression or armed rebellion, Article 352. 2. Emergency due to failure of constitutional machinery in the state. And 3. Financial emergency. If the President is satisfied that the security of India is threatened by war, external aggression or armed rebellion, Article 352, or if either on the receipt of report of the Governor of the state or otherwise he is satisfied that a situation has arisen in which the government of state cannot be carried on in accordance with the Constitution, Article 356, or a situation has arisen whereby the financial stability of India is threatened, Article 360, he may proclaim an emergency. A proclamation of emergency made under Article 352 may be revoked by a subsequent proclamation. Such a proclamation must be laid before each House of Parliament and ceases to operate at the expiration of 1 month unless approved by both Houses. The President may Doreen. 6. Diplomatic power. The President appoints ambassadors, ministers and consuls to other countries and receives in return corresponding foreign diplomatic representatives. He represents India in the international sphere and can negotiate treaties subject to ratification by Parliament, which has the power to legislate on all matters which bring India into relations with foreign countries. 7. Power to summon and address Houses of Parliament. I. The President shall from time to time, a. Summon the Houses or either House to meet at such time and place as he thinks fit, b. Prorogue the House, c. Dissolve the House of Parliament, Article 86, 1. 2. The President may send message to either House of Parliament whether with respect to a bill then pending in Parliament, or otherwise, and a House to which any message is so sent shall, with all convenient dispatch, consider any matter required by the message to be taken into consideration. Article 86, 3. 4. At the commencement of the first session after each general election to the House of the People, and at the commencement of the first session of each year, the President shall address both Houses of Parliament assembled together, and inform Parliament of the cause of its summons. Article 87. 8. Powers to give assent to bills, etc. When a bill has been passed by the Houses of Parliament, it shall be presented to the President, and the President shall declare either that he assents to the bill or that he withholds assent therefrom. But the President may, as soon as possible after the presentation to him of a bill for assent, return the bill if it is not a money bill, to the Houses with a message requesting that they will reconsider the bill or any specified provision thereof and, in particular, will consider the desirability of introducing any such amendments as he may recommend in his message, and when a bill is so returned, the Houses shall reconsider the bill accordingly, and if the bill is passed again by the Houses, with or without amendment, and presented to the President for assent, the President shall not withhold assent therefrom. Article 111, 1. No bill for the formation of a new state or the redistribution of the boundaries of any state shall be introduced in either Houses of Parliament except on the recommendation of the President. Article 3. 9. Ordinance making power of the President. Article 123. Article 123 provides that if at any time when both Houses of the Parliament are not in session and the President is satisfied that circumstances exist which render it necessary for him to take immediate action, he may issue such ordinance as the circumstances appear to him to require. The ordinances issued by him shall have the same force as on Act of Parliament. Such ordinances, however, must be laid before both Houses of Parliament and shall cease to operate at the expiry of the 6 weeks from the date of reassembly of Parliament, unless a resolution disapproving it is passed by both Houses before the expiration of 6 weeks. The President may, if he likes, withdraw such an ordinance at any time. An ordinance promulgated under Article 123 is a law having the same force and effect as an Act of Parliament. Hence, an ordinance will be void in so far it makes any provision which under the Constitution the Parliament is not competent to make. Thus an ordinance cannot violate the fundamental rights. 10. Privilege of the President. Article 361 guarantees the following privilege to the President. 1. The President shall not be answerable to any court for the exercise and performance of the powers and duties of his office or of any act done or purporting to be done by him in the exercise of those powers and duties. However, the conduct of the President may be brought under review by any court, tribunal or body appointed or designated by either House of Parliament for the investigation of the charge in impeachment proceedings. The immunity afforded to the President will not restrict the right of any person to bring case against the Government of India. 2. No criminal proceedings whatsoever shall be instituted and continued against the President in any court during the term of office. 3. No process for the arrest or imprisonment of the President shall be issued from any court during his term of office. 4. No civil proceedings in which relief is claimed against the President shall be instituted during his term of office in any court in respect of any act done or purporting to be done by him in his personal capacity whether before or after he had entered upon his office until a notice in writing has been given to the President. b. 2 months have passed after the service of such notice, and c. The notice states the nature of proceeding, the cause of action, the name, residence, and description of the party taking the proceedings, and the relief claimed. Q. 39 describe the qualifications, election, functions and the position of the Vice President of India. Ans. There shall be a Vice President of India. Article 63. The Vice President shall be elected by the members of both Houses of Parliament assembled at a joint meeting in accordance with the system of proportional representation by means of the single transferable vote, and the voting at such election shall be by secret ballot. Article 66. 1. The Presidential and Vice Presidential Election Amendment Act 1974 provides that the name of the candidates for Vice President must be proposed by 5 electors and be seconded by 5 electors, and also provides for the security of 2,500 rupees. The Vice President shall not be a member of either House of Parliament or of a House of the Legislature of a state. If a member of either House of Parliament or of a House of the Legislature of any state be elected Vice President, he shall be deemed to have vacated his seat in that House on the date on which he enters upon his office as Vice President. Article 66. 2. No person shall be eligible for elections as Vice President unless he a. is a citizen of India, b. has completed the age of 35 years, and c. is qualified for election as a member of the Council of States. Article 66. 3. A person shall not be eligible for election of a Vice President if he holds any office of profit under the Government of India or the Government of any state or under any local or other authority subject to the control of any of the said governments. Article 66. 4. A person shall not be deemed to hold any office of profit by reason only that he is the President or Vice President of the Union or the Governor of any state or is a minister either for the Union or for any state. Article 66. Explanation. The Vice President shall hold office for a term of 5 years from the date on which he enters upon his office. The Vice President may by writing under his hand address to the President, resign his office. The Vice President may be removed from his office by a resolution of the Council of States passed by a majority of all the then members of the Council and agreed to by the House of the People, but no resolution for the purpose of this clause shall be moved unless at least 14 days' notice has been given of the intention to move the resolution. The Vice President shall, notwithstanding the expiration of the term of office of Vice President shall complete before the expiration of the term. Article 68. 1. An election to fill a vacancy in the office of Vice President occurring by reason of his death, resignation or removal, or otherwise shall be held as soon as possible after the occurrence of the vacancy, and the person elected to fill the vacancy shall, subject to the provisions of Article 67, be entitled to hold office to the full term of 5 years from the date on which he enters upon his office. Article 68. 2. Parliament may make such provisions as it thinks fit for the discharge of the function of the Parliament in any contingency, not provided for in this chapter. Article 70. The Vice President of India shall be ex officio Chairman of Rajya Sabha, Article 64, and shall on any vacancy in the office of the President by reason of his death, resignation, or removal or otherwise act as a President until the date on which a new President is elected to fill such vacancy enters upon his office, even when the President is unable to discharge his function, until the date on which the President resumes his duties. Article 65. Q. 40 discuss the position of Prime Minister in the Council of Ministers. What are his powers and functions? Ans. Article 74. 1. Says that there shall be a Council of Ministers with the Prime Minister at the head to aid and advise the President, who shall in the exercise of his functions act in accordance with such advice. Article 74(2) then provides that the question whether any advice was given by the minister to President cannot be inquired by any court. According to Article 75(1), the Prime Minister shall be appointed by the President and other ministers shall be appointed by President on the advice of the Prime Minister. So the Constitution of India makes it obligatory for the President to appoint a council of ministers, and he must exercise his functions with the aid and advice of the ministers. The relation between the President and the Council of Ministers is confidential in view of Article 74(2). Position of Prime Minister. According to Article 75(1), the Prime Minister is appointed by the President and other ministers shall be appointed by President on advice of Prime Minister. In parliamentary system of government, the selection of the Prime Minister is an important function of President. The Prime Minister will be appointed that person who has majority of members in House of People. So in appointing the Prime Minister, the President can hardly exercise discretion, and President's choice to select Prime Minister is restricted to the leader of the party in majority in Lok Sabha or a person who is in position to win the confidence of the majority in that house. Thus the paramount consideration for the President in appointment of Prime Minister is to see that the person chosen has support of majority in the House. According to Article 75(3), Council of Ministers shall be collectively responsible to the House of the People. The Council of Ministers consists of three categories of ministers: Ministers of Cabinet rank, Minister of State, and Deputy Ministers. The Cabinet rank ministers are the heads of their departments. All Cabinet ministers are not members of the Cabinet. They attend the meetings of the Cabinet when specially invited by the Prime Minister and when the matter concerning their department is discussed by the Cabinet. The salaries and allowances of ministers shall be such as Parliament may from time to time by law determine. The Ministers of State are formally of Cabinet status and are paid the same salary as the Cabinet ministers, and they hold independent charge of their department. The Deputy Ministers are paid lesser salary than the Cabinet rank ministers and have no separate charge of a department. Their task is to assist the ministers with whom they are attached to in their administrative duties. The Cabinet is the smaller body of the Council of Ministers. Though the Indian Constitution nowhere mentions the word Cabinet, but it does incorporate the essentials of a Cabinet system of British government. In Britain, the Cabinet is a child of chance and is essential based upon convention, i.e., unwritten rules. The Cabinet is thus an extra-constitutional growth based upon convention. The Cabinet is the supreme policy-making body. The Council of Ministers never meet as a whole, it never discusses policy matters. All senior-most ministers are the members of the Cabinet. The Council of Ministers shall be collectively responsible to the House of the People. The minister must be a member of either House of Parliament. A non-member can become a minister. Article 75(5) provides that a minister who for a period of 6 consecutive months is not a member of either House of Parliament shall cease to be a minister at the expiration of that period. Thus, there is no legal bar that a minister must be a member of Parliament. An outsider may be appointed a minister, but he must become member of Parliament within the period of 6 months. If he is not elected within the time mentioned above, he is bound to resign from the legislature. In S.P. Anand v. H.T. Dave Govda, AIR 1997 SC-72, it was held that a person who is not a member of either House of Parliament can be appointed by Prime Minister for 6 months, as per Article 75(5). However, in B.R. Chauhan v. State of Punjab, AIR 2001 SC 2707, Supreme Court has held that a non-member who fails to get elected during the period of 6 consecutive months after his appointment as minister cannot be reappointed as minister. The powers and functions of Prime Minister. The Council of Ministers headed by the Prime Minister is the ex facto executive head of the state, the President being the formal executive head. The function of the Council of Ministers is to aid and advise the President. Previously there existed a controversy as to whether the above tendered by the Council of Ministers was binding on the President. The Supreme Court had decided in Ram Javaya v. State of Punjab, AIR 1995 SC 549 and Shamsher Singh v. State of Punjab, AIR 1974 SC 2193 that the advice of Council of Ministers was binding on the President. After Constitution, 44th Amendment Act, 1978, the President may require the Council of Ministers to reconsider such advice. Article 74(2) provides that the question whether any and if so what advice was tendered by ministers to the President shall not be required into in any court. The Council of Ministers with Prime Minister at its head normally conducts the administration of the Union government through the various departments, formulates the policy of the government, determines its legislative program, and uses its initiative in the introduction and passage of legislation. It is the cabinet headed by the Prime Minister that prepares the Union budget and moves demands for grants. The foreign policy of India is formulated by the cabinet. Even the emergency powers of the President are actually exercised by the cabinet. In short, the Council of Ministers with Prime Minister at the head is the actual executive of the Union and the President is merely its ceremonial head.